and in some cases, to strengthen and sharpen skills of settlement. For example, there are many groups of persons who are already involved in settling matters. They're village elders, they're religious persons, they're community leaders. What mediation training will do is to allow them to acquire a more effective negotiation skill to do what they are already been doing, which is to try to settle matters. Due to the COVID pandemic and the COVID restrictions of social distancing, online dispute resolution has taken a leap forward. And this is now in a redesigned justice system. The requirements for virtual mediation are very simple. You can just need a smartphone, everyone has that, or a computer with a webcam. Internet access, perhaps a telephone number, an email address. And they are the adaptable applications, such as the one we're using here, Zoom. There's also Google Meet, Microsoft Teams, or Skype. The online sharing screen is very useful to review and contribute to core mediation documents, such as draft settlement agreements, although parties may still prefer to do this by email to ensure any changes to the agreement can be fully tracked. So there must be now, in order to emphasize the mediation, the role of mediation in resolving disputes, is to build capacity of training mediators, having them there. There is a culture shift and the additional benefits of virtual mediation. It will save travel time and, of course, cost and expense. So it is my view that online mediation is the forward way to go. I'll give an example of mediation training that I did recently, or the Mediation Services International did recently, in terms of sharpening skills. We trained a group of persons called Tushaus, which are an indigenous group of people. Their role in the communities, in a rural community, is as a peacemaker. They have a leadership role, and they are always the parties appointed to settle disputes. When we did a basic training course with them, at the end of the day, the review was simply that, yes, they had been resolving disputes all the time, but what the mediation training did for them was to allow them to develop a skill to make their settlements more effective and efficient. And in particular, they emphasize the caucus or a private meeting, which is done in a mediation process. So these are the advantages of having mediation training in a society in order to resolve disputes rather than rely on the court. And in some ways, mediation is more effective and more appropriate than arbitration. I believe that my time limit is up, so I'll end there. And I once again thank you for the honor and privilege of addressing this distinguished conference.
Thank you so much, Ms. Jamila A. Ali, for the wonderful presentation you made at the conference today. Thank you so much. Now we have our chief guest, Mr. Justice Muhammad Iman Ali, Most Senior Judge, Appellate Division, Supreme Court of Bangladesh, and recipient of International Mediation Award. Sir, can we have you on?
Yes, thank you very much. May I first of all thank Jamila very much for giving us this wonderful background and detailed analysis of what mediation should be and how the mediation training should take place. It's now 2 a.m. in the morning where she is, and I'm very grateful that you have been able to be present with us. Honorable Chair, Keynote Speaker, Justice Joyce Aloch, distinguished guests, my colleagues, judges of the Supreme Court, ladies and gentlemen, good morning, assalamu alaikum, and adab. This is the month of our victory, December. I wish to begin by paying homage to the millions who sacrificed their lives for our freedom. And in particular, we must pay homage to the father of our nation, Bangabandhu Sheikh Mujibur Rahman, who was a champion for the rule of law and justice for all. At his beck and call, 7.5 crores of Bengalis rose and fought for humanity and for the rights of the citizens of this country. On 16th of December, only a few days ago, we celebrated our 49th Victory Day. And I remember 49 years back, on that day, we chanted Joy Bangla in the streets of England. With due reverence to the wishes of Bangabandhu Sheikh Mujibur Rahman, I should be speaking in Bangla, but then for the benefit of many colleagues, friends here who do not speak Bangla, I will continue and speak in English. Now we have achieved our freedom. In fact, we achieved a second liberation again in December, 6th of December, 1990. But then have we achieved justice for all? On 18th of December, 1972, while opening the Supreme Court of Bangladesh, Bangabandhu Sheikh Mujibur Rahman said, and I quote, "The rule of law will be established in the country because we believe in the rule of law." However, in days to come, Bangabandhu was saddened by the delay in disposal of cases and that his people were not getting justice. He said that because justice was not quick, cheap, and accessible for the majority of the population. And that goes for today also. The latest figures show that approximately 4 million cases are pending in our courts, of which about 3.5 million are pending in the lower courts. With only 1,700 judges in all the courts, backlog is increasing exponentially. So we have to think about other means of disposing of our cases, because otherwise justice has become inaccessible. And because of the backlog, in 2003, ADR was introduced by changing or amending our Code of Civil Procedure. And in due course, in 2006, mediation at the appeal stage was also introduced. In 2012, mediation was made mandatory. Section 1889A, referred to by Mr. Goswami earlier, says that after filing of the written statement, if all the contesting parties are in attendance in court in person or by their respective pleaders, the court shall, by adjourning the hearing, mediate in order to settle the dispute. The disputes in suit or refer the disputes to the legal aid officer for mediation, or give the case back to the parties or their pleaders, or engage a mediator from a panel, which will be made up of the persons named and detailed in subsection 10 of that section by the district judge. And we now have a situation where any agreement reached through mediation will be enforced as a decree of the court, and there will be no appeal from it. And to encourage mediation and other ADR schemes, the law provides for refund of the fees that anyone may have paid for at the time of filing of the suit. And subsequently, much more has been done in order to encourage mediation. I will not go into detail about the process of mediation, as that has been done very aptly by Justice Joyce Aloch, and also added to by Jamila. Now, mediation, what it is, has already been explained, and the law itself explains mediation shall mean flexible, informal, non-binding, confidential, non-adversarial, and consensual dispute resolution process in which the mediator shall facilitate compromise of disputes in the suit between the parties without directing or dictating the terms of such compromise. So in a nutshell, we have precisely what the mediation process entails. Now, special provisions for mediation for suits filed before 2012 were also introduced in the year 2012, so that cases which had already been pending in the system before that date could now be brought into the system of mediation. As has been mentioned, there are other alternatives to mediation, including arbitration. I have said in the past, and I will say it again, arbitration has by now reached such a stage where it has become very technical and perhaps not as accessible as what it was aimed to be in the beginning. Moreover, we have come across many cases where a party who loses the arbitration because of the amount of the award, they go to the court. Or even during the process of arbitration, in many cases, through very small divergence in the procedural or small defects in the procedures, they go to the court, and each time is taken in order to get through the procedural matters. As a result, arbitration takes a long time for disposal, and it becomes expensive, and therefore the purpose of arbitration to achieve decisions quicker and more cheaply is defeated in the process. So that is why I would say that mediation is probably a better choice than arbitration. More so, if you look at our Arbitration Act, the Act itself says that if during the course of arbitration, before the award is pronounced, anyone wants to go for mediation or the arbitrator suggests that mediation is a better option, then the mediation can be opted for. So therefore, I again say mediation is a better option than arbitration, because arbitration can and does very often take a long time. I remember a case which I inherited, which started in the year 1966, and I managed to get the result positive in favor of my clients in the year 1996. And by that time, the company against whom I won the case had become bankrupt. So I won the case and I lost everything. So there, arbitration, again, I would say, is possibly no more a good solution. Now, being the last speaker is always very difficult. I'm at a disadvantage because many of the notes that I made to speak on has already been spoken. So I have nothing more to say. But then there is also an advantage, because then I can say something totally different. And because I'm the chief guest today, nobody can say or stop me from speaking more. Now, I just want to say very quickly that disputes arise. Disputes arise all the time. We think of the time we spend on disputes in the house, disputes that arise between ourselves and our children, our spouses, disputes that arise within our organizations. And disputes have to be resolved. And I suppose in the family it's resolved very quickly. But then there used to be a system whereby disputes were no disputes. In the old days when, for example, the landlord, the superior lords, the rajas and the kings and so on had dispute resolution in their own hands. They said it and it was done. Whatever they said was the law. Whatever they said was the resolution. But those days are gone. These days, even children don't listen to the parents. So dispute resolution has to be on a more horizontal level, on a more active participation level. So each person has their say, and there has to be a resolution which is acceptable and agreeable for all. So we negotiate with our parents, with our children, with our colleagues. Now, I just want to give you, I find this quite amusing, the 3 examples of dispute resolution that I've come across. One example is when 2 children are fighting over an orange. Now, how do you think the mother will solve that problem, that dispute? She can simply split the orange into 2 and give each one of them half each. Now, that is a solution, but is that the best solution? If, for example, she had spoken to the children, one might have said, oh, I just want the rind to make my cake. I don't need the orange, the inside, the fruit. And the other one might say, oh, I don't care for the rind. I don't eat the rind. I only eat the orange. And if the mother had given the rind to one and the orange to the other, the fruit to the other, then each would have been 50% better off. Now, that is the beauty of mediation. You talk to the persons concerned, you find out what is their interest, you find out what is best for them, and then you decide accordingly. Half an orange rind is better than none, but then on the other hand, the rind of a full orange is better than half the rind. Now, another example that I have come across and I'd like to share with you is a man who leaves a will that his 3 sons, I'm sure so many of you will have come across this example, will get, the eldest son will get half of the share of his property. The second son will get a third share of the property, and the youngest son will get 1/9 share of the property. Now, as it happens, when he dies, there are only 17 cows. Now, how do you divide 17 cows amongst the children in the line of the will made by their father? You cannot divide 17 by half and give 9 or whatever to the eldest child. You cannot divide 17 by 1/3, 3. You cannot divide 17 by 9. So they go to a mediator, someone, an independent person, a third party who's not interested in the property. And the third party thinks about it and it says, I have a cow, you take that and then see if you can deal with it. So now they have 18 cows. The eldest one gets 9, that's 50%, half. The next one gets how many? 6. And the next one gets 2. So 9 plus 6 plus 2 is 17. And there's 1 cow left over for the person who was kind enough to lend it to them in the first place. That is mediation. So these are ways of deciding how best to settle a dispute, but then settle a dispute which will be for the benefit of all. Yes, we have a situation of win-win. In arbitration or litigation, one party wins, the other party loses. And there's acrimony. And that remains through generations. Whereas in the mediation, because both parties agree to the final end result, everybody is happy. And then there is no acrimony. So again, I have to say that mediation is a better solution. So I don't want to go into details of what mediators should be, how they should be trained, etc. That has been dealt with by Jamila, and that I think is probably subject matter of a different occasion when we can talk about what particular training skills are necessary, or what particular skills are necessary for a mediator. For example, we have already heard that mediator has to be a good listener. But I would say the mediator has to be a good psychologist, to be able to understand behavior, to be able to understand emotion of the parties. Because, you know, whenever you have a disputed situation, the parties are already very emotive. They are already worked up. They want to, each one of them wants to win. But then when they are made to realize by listening to the other, they then calm down. They go back. They step back and think, well, what is it I want? The mediator helps them to consider the other party's views. The mediator doesn't decide. He does not advise, but he simply acts as a communicator in between the go-between in the two parties. So I again say that this is possibly now the best method of alternative dispute resolution. I've already spoken a lot. I don't want to take any more of your time, but particularly I don't want to keep Jamila up any further than what's necessary is 2:30 in Guyana. I thank you all very much for giving me the opportunity to be here today, to speak to you all. I'm very sad that we couldn't go to Rangpur to be there physically. We had already made the plans and people were waiting for us in Rangpur, but I'm very sorry we couldn't make it. We hope that the new year will bring us better tidings than it has for the past year. And I hope that there will be a solution to the COVID. In spite of that, I think what the COVID has done for us is has opened new avenues of having mediation over the internet, which I think is not a bad thing, because as has been already said, it saves costs, it saves time. And well, think of the amount of money that has been saved by the organization today by not having us all in Rangpur. But then I do miss being physically present there. Thank you again all very much for your patient hearing, and I wish you all success. Thank you.
Thank you, sir.
We are waiting for you, sir. We hope that very soon you will come Rangpur, and we will meet with you, for Rangpur.
I agree with Khandakar Rafiq. Thank you.
Thank you, sir. Thank you so much for your wonderful speech. Actually, I'm touched beyond words. There was so much to learn from you, and we have heard about your experiences and new views of mediation and the dimensions of mediation. Thank you so much. Moving to our next part, discussion and insights session. I would like to call upon our today's guest of honor, Mr. Justice Ahmed Sohail. He is a judge of High Court Division, Supreme Court of Bangladesh.
Thank you. Honorable Chief Guest, Mr. Justice Muhammad Iman Ali, Honorable Judge of Appellate Division, Supreme Court of Bangladesh. Honorable Keynote Speaker, Lady Justice Joy Saluch, Member, International Advisory Board of United Nations Organization, Fund and Program, and former Judge of International Criminal Court, Hague, Chair of Advisory Board, BIMS, and Africa-Asia Mediation Association. Honorable Mr. Justice Somendra Sarkar, former Judge, Supreme Court of Bangladesh. Mr. S.N. Goswami, eminent lawyer of Supreme Court of Bangladesh and Chairman, Bangladesh International Mediation Society, BIMS. Mediators and the friends from the mediation community, distinguished guests, learned speakers, participants, ladies and gentlemen. It's afternoon now, so very good afternoon to all of you. I consider it a great honor and privilege for me to address before you as a guest of honor of BEAMS Regional Conference Rangpur. Although we're supposed to be there physically, today we are doing conference online. It's a new dimension today. Thank you very much for inviting me to this conference, and I'm pleased to be here with you today for giving me the opportunity to share my experiences with you. The Honorable Keynote Speaker, Lady Justice Aluch, has already discussed elaborately on the subject matter and give us the ideas about mediation thoroughly. Also, Honorable Chief Guest, Mr. Justice Iman Ali, in his humorous speech, has already discussed a lot of things about mediation and the present condition of mediation. However, I would like to give some of the tips on the subject matter very precisely. In modern world, alternative dispute resolution has become very popular as an alternative route for reaching a speedier and less expensive mode of settlement of disputes. It is usually considered to be alternative to litigation. It includes mediation, arbitration, negotiation, and conciliation. It reminds me the famous words of US President Abraham Lincoln emphasizing the profound significance of ADR. May also be recalled, quote, discourage litigation, persuade your neighbors to compromise. Whenever you can, point out them the nominal winner is often a real loser in fees, expenses, and waste of time. Most of the countries of the world are now adopting ADR mechanism and achieve huge success in reducing backlog of cases and ensure justice, access to justice for all sectors of the people. ADR as a method of dispute resolution has already been introduced in Bangladesh in the early days after independence. Arbitrations in Bangladesh were governed by Arbitration Act 1940, Bangladesh becoming a party of the 1958 New York Convention, and based on the ancestral model law has enacted the Arbitration Act 2001. However, with all its benefits, is not mediation with all its benefits is not practiced or promoted significantly in the context of Bangladesh till date. Now let me focus on the subject matter of conference, role of mediation in resolving disputes. Basically, English law provides no definition of mediation. In general, mediation, we have already heard, that's a voluntary, party-centered, and structured negotiation process where a neutral third party assists the parties in amicably resolving the dispute by using specialized communication and mediation negotiation techniques. According to International Mediation Institute, mediation is negotiation facilitated by a trusted neutral person. In mediation, the parties retain the right to decide for themselves whether to settle a dispute and the terms of any settlement. Although the mediator facilitates their communication and negotiation, the parties always retain control over the outcome of the dispute. This is the main benefit actually. The parties retain the right to decide for themselves whether to settle a dispute and the terms of settlement of the dispute. Even the court has referred the case for mediation or mediation is required under the contract or statute. The decision to settle and the terms of settlement always rest with the parties. The right of self-determination is an essential element of the mediation process. It results in a settlement created by the parties themselves and is therefore acceptable to them. The parties have ultimate control over the outcome of mediation. Any party may withdraw from the mediation proceedings at any stage before its termination and without assigning any reason. The parties and not the mediator are the focal point of the mediation process. It encourages the active and direct participation of the parties in the resolution of their disputes. Though the mediator and other participants also have Active roles in mediation. The parties play the vital role in mediation process. They are actively encouraged to explain the factual background of the dispute, identify the issues underlying interests, generate options for agreement, and make a final decision regarding settlement. Mediation process is informal. That means it is not governed by the rules of evidence. We have already heard from Justice Luis and formal rules of procedure. It is not an extemporaneous and casual process. The mediation process itself is structured and formalized with clearly identifiable stages. However, there is a degree of flexibility in following these stages. Mediation is, in essence, is an assisted negotiation process. Mediation addresses both the factual, legal issues and underlying causes of just dispute. Thus, mediation is broadly focused on the facts, law, and the underlying interests of the parties as personal, business, commercial, family, social, community interests. The goal of mediation is to find a mutually acceptable solution that adequately and legitimately satisfies the needs, desires, and interests of the parties. Advantages of mediation are many. It provides an efficient, effective, speedy, convenient, and less expensive process to resolve a dispute with dignity, mutual respect, and civility. Mediation can start before any litigation or any stage during the process of litigation. You can make your own decisions and reach agreements with which you and other party may be more willing and ready to comply. And another benefit it's already said by Justice Aluch and Jamila and Justice Imal is the settlement terms can be kept private and confidential. Another advantage is that discussions during mediation session are without prejudice. That is what is said by you or other party will not be used against you as evidence if your case proceeds to trial. Mediation is conducted by a neutral third party, the mediator. The mediator remains impartial, independent, detached, and objective throughout the mediation process. In mediation, the mediator assists the parties in resolving disputes. Mediator is a guide who helps the parties to find their own solution to the dispute. Mediator's personal preferences or perceptions do not have any bearing on the dispute resolution process. In mediation, the mediator works together with parties to facilitate the dispute resolution process and does not adjudicate a dispute by imposing a decision upon the parties. Mediator's role is both facilitative and evaluative, which we have heard already from the earlier speakers. Mediation is a private process. It's not open to public. Mediation also confidential in nature, which means that statements made during mediation cannot be disclosed in civil proceedings or elsewhere without the written consent of all parties. Any statement made or information furnished by either of the parties and any document produced or prepared for during mediation is inadmissible in any proceeding. Any concession or admission made during mediation cannot be used in any proceeding. Further, any information given by the party to the mediator during mediation process is not disclosed to the other party unless specifically permitted by the first party. No record of what transpired during mediation prepared. Any settlement reached in a case that is referred for mediation during the course of litigation is required to be reduced into writing, signed by the concerned parties, and filed in court for passing of an appropriate order. A settlement reached at a pre-litigation stage is a contract which is binding and enforceable between the parties. In the event of failure to settle the dispute, the report of the mediator does not mention the reason for the failure. That's another advantage. The report will only say not settled. Mediator cannot be called upon to testify any proceeding or to disclose to the court as to what transpired during the mediation. Parties to the mediation proceedings are free to agree for an amicable settlement, even ignoring their legal entitlement or liabilities, or in a particular case need not be confined to the dispute referred, but can go beyond and proceed to resolve all other connected or related disputes also. Now, conflicts have been within the society since creation, actually. Conflicts, disputes cause both positive and negative responses depending on the way we treat them when they arise. Disagreements are indeed a social process which is a common and essential feature of human existence in the world. Hence, mediation as an alternative dispute resolution is becoming a more peaceful and internationally accepted solution in order to end conflict. Mediation can be used to resolve disputes of any magnitude. International mediation is another aspect. International mediation in violent national conflict has long been undertaken by the United Nations, the African Union, and other multilateral organizations. In Africa alone, over the past 3 decades, mediators have labored to end a deadly conflict in Angola, Burundi, the Comoros, the Democratic Republic of Congo, Ivory Coast, Kenya, Liberia, Madagascar, Rwanda, Somalia, Sudan, Uganda, and Zimbabwe. Mediation may be carried out by non-governmental organizations, the international community, or the Red Cross. Intervene when there are armed conflicts and abuse of human rights, but at the same time keeps away from political disputes. Further, where mediation is successful, the content of the peace agreement has a major bearing for better or worse on justice, security, power, governance, respect for human rights, and potential for violent conflict in the post-war society. Mediation and negotiations are thus the bridge, sometimes tenuous and sometimes robust, between war termination and long-term peace building and state building. There are mainly 2 types of mediation we have already heard, so I don't want to discuss this. The court-annexed mediation and private mediations. I rather escape this one. There is no strict requirement who can be mediator. Mediators usually come from various professional backgrounds and have undergone training in mediation skills and techniques so that they know how to conduct the mediation process in unlocking negotiations that have become deadlocked and in keeping everyone focused on finding a solution. A mediator is not an adjudicator. In mediation, the mediator is only a facilitator and he does not suggest or make any decision. The decision is taken by the parties themselves. It is necessary that a mediator must possess certain qualities, such as high standards of honesty and integrity in conduct and behavior, maintain neutrality, objectivity, and not judgmental. He must have patience, persistence, and perseverance, good communication skills, open-mindedness, flexibility, creativity. It is said that a person who is selected to perform a particular job may commit errors if he is not properly trained for it. Therefore, I believe the mediators must have the above qualities. Definitely. Most mediation proceeds as follows. I have identified 6 stages. It's already, some of them already discussed, so I rather skip it, but I'll mention just the headlines. The mediator's opening statement. In this stage, after disputants take the seat and the mediator introduces everyone and explains the goals and rules of mediation, something like that. Stage 2, disputants' opening statements. Each party is invited to describe the dispute and its consequences, and financial and otherwise. Stage 3 is joint discussion. The mediator might encourage the parties to respond directly to the opening statements, depending on the participants' respectivity, and attempt to further define the issues. Stage 4, private caucus. The private caucus is a chance for each party to meet privately with the mediator. Each side will be placed in separate room. The mediator will go between two rooms and discuss the strength and weakness of each position. Stage 5, joint negotiation. The mediator might bring the parties back together to negotiate directly, but this is unusual. The mediator usually does not bring the parties back together until a settlement is reached. So that's important. Unless the settlement is reached, the mediator does not bring the parties. And then if the settlement doesn't reach, then the mediation is over. Closing session. If the parties reach an agreement, the mediator will likely put his own provision in writing, main provisions in writing, and ask each side to sign the written summary of the agreement. If the parties did not reach an agreement, the mediator will help the parties determine whether it would be fruitful to meet again later or continue negotiations over phone or other way. Then another aspect of meet-arb clause is mediation and arbitration. Parties first reach agreement on the terms of the process itself. Unlike in most mediations, they typically agree in writing that outcome of the process will be binding. Next, they attempt to negotiate a resolution to their dispute with the help of a mediator. If the mediation ends in an impasse or issues remain unresolved, the process is not over. At this point, parties can move on to arbitration. The mediator can assume the role of arbitrator if he is qualified to do so, and render a binding decision quickly based on his or her judgment, either on the case or as a whole or on the unresolved issues. Alternatively, an arbitrator can take over the case after consulting with the mediator. Bangladesh is yet to use meet-arb types of provisions in local contracted disputes. Actually, history of mediation goes back to ancient Greece, where village elders used to mediate local disputes between the villages. The activity of mediation appeared in very ancient times. Mediation is not something new in this subcontinent. Like India, Bangladesh had also utilized the system called the Panchayat system, whereby respected village elders assisted in resolving community disputes. Such traditional mediation continues to be used even today in villages, which is called Salish. Now let us focus some on the Bangladesh legal system, which is now overburdened. We have already heard from our Honorable Justice Mr. Iman Ali, by large backlogs of cases which effectively deny the citizens' right to redress. The delay and inefficiency most prominently affect the poor, who are also hampered by the expense of the dispute resolution process. Money often matters more than merit, making cost concerns crucial. Most of the Bangladeshi people cannot even afford to reach the doors of the courts and derive any benefits of their services. When the resolution of these cases is delayed, total charges paid to the lawyers increase with consecutive court appearances. The delays themselves also are caused partly due to lack of judges. Moreover, poor knowledge of ADR of the all parties concerned, lack of encouragement from the lawyers, tendency to harass the other party through a legal court battle, lack of enthusiasm from the judges who feel that sanctity would be cut down, disparity between the parties, lack of publicity, lack of trained mediators are some of the reasons for not getting the proper success in mediation in Bangladesh. Hence, in my view, ADA should be made mandatory. There should be separate establishments for mediators where skill training will be administered. But hope must not be lost. With extensive training, more publicity, more awareness, creating events across the country, along with the involvement of stakeholders over dialogues, should have brighter future for mediation in Bangladesh. There's also nowadays out of court NGO-based mediation is also seen traditional studies conducted by village leaders to resolve local dispute. The whole process is moderated and facilitated by the NGO staff. The Madaripur Legal Aid Association, Bangladesh Legal Aid and Services Trust, BLAST, Ainu Shalish Kendro, Nagorik Uddog, all are involved in NGO-based out-of-court mediation in Bangladesh. Now let us examine some of the provisions relating to mediation in our legal system of Bangladesh. It's already there actually. We don't use it properly. The provision for mediation has been inserted into the Legal Aid Amendment Act 2015, where before filing a case with the help of government legal aid, it is suggested to resolve the dispute via mediation. Bangladesh International Arbitration Center, BIAC, has their own BIAC Mediation Rules 2014 and Code of Conduct 2014, which is later on modified and in the year of 2019, and they have now Mediation Rules 2019, which was adapted. Bangladesh International Mediation Society also provides mediation service to help resolve civil and commercial dispute, both domestic and international nature. It has its own mediation rules and code of conduct as well. Furthermore, there are provisions relating mediation of disputes in the statutory laws of Bangladesh. The Code of Civil Procedure 1908 was amended to provide for a scope for mediation in the appellate court, and as well in which is mentioned in Section 89 of Code of Civil Procedure. Family Court Ordinance 1985. After filing the written statement, the family court shall fix a date for a pre-trial hearing of the suit. The date fixed for the pre-trial hearing, the court shall try to compromise and go for reconciliation between the parties. In the Village Court Act 2006, the village court shall hear both the parties and shall take initiation for conciliation between the parties. And Section 22 of Arbitration Act also provides scope for mediation. Moreover, Author in Adalat Ain 2003 provides for settlement of any dispute through mediation. Section 22 of Author in Adalat Ain 2003 talks about settlement conference after the filing of the written statement. Strategies such as training judges and lawyers to practice mediation, binding mediation outcomes through court degrees, etc., have amounted to a high rate of disposal of cases. After the alternative impressive success of mediation in family courts, mediation was gradually included in various civil laws in Bangladesh, such as Code of Civil Procedure, following an amendment, it's already said, in 2012. Furthermore, Section 345, in criminal proceedings, there is also some sort of mediation, scope of mediation in Bangladesh legal system, actually. Section 345 of Code of Criminal Procedure, 1898, provides scope for mediation for the offenses mentioned. It's already mentioned in the chart, so I don't discuss that. Now come to the judicial landscape of Bangladesh. According to the latest statistics placed before the Parliament by Honorable Law Minister of Bangladesh, Mr. Anisul Haq, that more than 4 million, nearly 4 million cases are now pending. Our Honorable Chief Guest Mr. Justice Iman Ali already mentioned about that, the higher courts and the lower courts across the country. From these statistics, it's needless to mention anything about the necessity of mediation and arbitration proceeding judicial system of Bangladesh. It is high time to successfully introduce ADR, especially mediation in Bangladesh, to reduce the huge backlog of cases. I note that Bangladesh International Mediation Society, which has started its journey on 31st May 2017, and within this period, it has organized dialogues, workshops, seminars, conferences on regular basis to create awareness about and arbitration on regular basis, successfully both domestically and internationally. It has successfully providing training. Sorry, my microphone was muted. Our economy is developing very rapidly, bringing its business into close contact with the outside world. Many foreign companies are now investing in Bangladesh. Therefore, effective steps towards the alternative dispute resolution is needed to make Bangladesh an investment-oriented country. I believe that Bangladesh government will continue to strongly support the use of mediation and arbitration and encourage efforts to develop the field of mediation through research, studies, and training, and help to create a better business-friendly environment in Bangladesh. There are some disadvantages as well in the mediation process, so I should highlight that as well. Though many contractual parties are required to enter mediation in the event of a dispute under a mediation clause in the contract, mediation is not always appropriate. For instance, if the either party does not have the legal right to enter into an agreement to mediate, or if you need immediate injunctive relief, or if the constitutional rights of one or other parties are affected, or if there is no genuine commitment to resolve a dispute, mediation will not be available. At the start of the mediation process, the parties should agree on some sort of structure or framework that mediation should follow, including an appropriate timetable to have the mediation a successful ending. Now, I'm discussing the light of COVID-19. In 2020, due to pandemic, whole world is in crisis. We all know that. Our world seems more unsettled ever before in our lifetimes, as the coronavirus pandemic has killed and sickened millions and disrupted our daily routine in countless ways. The functioning of the courts have been particularly hindered all over the world. Many courthouses have been closed, and judges and lawyers have been also forced to postpone in-person trials and hearing for maintaining social distancing, and also due to lockdowns. Although the courts are functioning virtually, however, methods of alternative dispute resolution like mediation and arbitration are flexible tools that even during a pandemic can provide litigants and backlog courts some much needed relief. Mediation have traditionally asserted parties to resolve disputes through face-to-face processes conducted in conference rooms or courthouses. Mediation practice has gradually adopted in response to the COVID-19 crisis across the country. Mediations are increasingly using different forms of technology now and online dispute resolutions, which allows parties to negotiate remotely to continue to resolve these lawsuits and disputes even in an age of cancelled hearings, postponed trials, and social distancing by virtually using smartphone, tablet, computer, or other similar technology, particularly from any location. The delay in judicial proceedings in response to COVID-19, mediation provides a vital alternative to court in many situations. I'm taking long, sorry, it's nearly finished. Mediation is a developing concept in Bangladesh. Efforts are being made to make mediation fully developed tool for resolution of disputes. Training is necessary for a mediation to learn the fundamentals of mediation. Training is required for a mediator irrespective of his background, whether he is judicial officer or advocate. Now I give some idea about the success rate of mediation. It's necessary because otherwise we won't be inspired to go for mediation. In 2016-17, Singapore and Brazil have passed laws promoting civil and commercial mediation. In fact, Japan has been using mediation in commercial disputes since 1922. The European Union 2008 issued a directive mandating mediation mechanism to be adopted for resolving interstate civil and commercial disputes. As per studies in European Union, it takes 43 days and euro 3,371 to resolve a dispute using mediation, as compared to 555 days and euro 9,179 to get a final court order. The US Department of Justice alone saves 70 million US dollars and 2,733 months of litigation by using mediation. It is their statistics. Mediation is currently seeing a success rate of 80% to 85% throughout the Western world. From the Bangladesh perspective, issues with enforcement of contracts and awards and huge case backlogs in Bangladesh courts provide wide scope for implementation of mediation. Bangladesh has unprecedented progress in the latest decade in any indicator of economic growth and social development. This is the year of golden jubilee of independence of Bangladesh. The country steps into 50 years of its glory. Today, it is important for us as a nation to improve ease of doing business in our country, and mediation initiative should be the first step in this direction. Now, summing up my speech, it can be said mediation cases have many significant advantages over traditional lawsuits, which I've already said is quicker, less expensive, less formal and confidential, and the parties have their control over the mediation process. Everything has advantages and disadvantages. So there's disadvantage that there's no guarantee about the success of mediation. If the other side is adamant that they are right, refuses to listen to what you have to say or won't agree to mutually beneficial terms, then the case could end up going to court anyway. You might want to go public as because mediation is confidential, but in some cases this might not work in your favor. If you have been accused of something publicly, then you may want the public vindication that comes with the court case. Another problem is there's also growing fear among the lawyers, which need to be resolved actually, that regarding mediation, that cases being resolved quickly would reduce their number of practicing lawyers and consequently the amount of fees to be collected from clients. This is actually, they need to be changed their mentality in that case, because mediation, they can also, a part of the, they can be a mediator and as well as lawyer. So I don't think so that will hamper their profession. Mediation requires cooperation of both parties. Ultimately, in mediation, both sides coming to the table, working towards a resolution. If one side refuses to do so, then mediation may not work. For a successful resolution, we need not reach. So these are some of the disadvantages. And one thing it is said that there is no, of course, there is of course no one size fits all solution. We have to remember that. And I understand that mediation should not be viewed through rose tinted glasses. You should always keep in mind the nature of your case and the personality traits of other side before deciding to go through with mediation. This very common course said by William E. Gladstone that justice delayed is justice denied. Also, Martin Luther King Jr. said, injustice anywhere is a threat to justice everywhere. So we all have to keep in mind in all these principles for a future life to ensure justice for all. Mediation cannot be substitute a formal justice system, judicial system, but can complement and support it. Considering the advantages of mediation in the legal field, I would like to conclude my speech by quoting Joseph Greenbaum. I quote, an ounce of mediation is worth a pound of arbitration and a ton of litigation. Before I wrap up, I express my sincere thanks to the guests from overseas for attending the conference and my heartfelt gratitude to the organizers of this August conference for inviting me here. I wish this conference a resounding success. I hope and pray that COVID-19 pandemic will come to an end very soon and all of you be safe during this time. Thank you all for listening to me with patience. Thank you.
Thank you, Justice Ahmed Sohail, sir. It was an immense pleasure.
Sorry, I was too long, so sorry about that.
That's okay, sir. It was an immense pleasure for us that you joined our event and bested us by being guest of honor today. Your precious time was of great importance for us. Thank you, sir. Thank you.
Thank you.
Our next guest speaker, well, I have a small announcement. Our guest speaker, Professor Dr. George Yesuveda Victor sir, who is the chairman of Bangladesh India Mediators Forum, that is BIMF, international arbitrator, mediator, and admiralty, contracts lawyer, chartered engineer and physicist, certified dredge master, and also the faculty member of Bangladesh International Mediation Society, BIMS, is absent today due to some unavoidable circumstances. So without wasting any time, we would like to go to our next speaker today. Our next guest speaker, I would call upon Madam Priyanka Chakraborty. She is an advocate and accredited mediator and the Executive Secretary General of Bangladesh International Mediation Society. And your time allotted is for 30 minutes, ma'am.
Thank you so much, Sylvia, for such a lovely introduction. Good afternoon, everyone. And I'm really glad to have the opportunity to speak up my mind amongst such eminent guests. Special welcome to our chief guest, Justice Ali sir. I have had the opportunity to hear a lot of speeches from you beforehand, and it is always very informative. Thank you so much. Also, I would like to thank our keynote speaker, Lady Justice Aluj, and our chairman, Sir Goswami, sir, for arranging this and giving around the opportunity. So I just have a small presentation. I would try to keep it crisp and short so that we could have discussion if you want to further. I'll just share my screen. Sylvia, please do let me know if you can see that.
Yes, we can see.
Just visible, right? Okay, great. Thank you so much. So Well, starting from today morning, we have learned a lot about what mediation is, and what is the exact process going to be. What are the ifs and buts? What are the advantages, and what are the practical challenges we are facing, and how to go about it? What is the entire process of mediation, if to be spelled out? So I just want to discuss something which is a bit more into the core formation of the process of mediation, and I want to talk about the importance of communication in mediation. If I have to say, communication skills are extremely important for anybody and everybody. But when it comes to mediation, it is definitely the primary weapon or the primary skill set that you need. Not only as a mediator, but also as people who are participating, also as mediating advocates. So this is a very important skill set. I'm going to talk majorly about the verbal communication skills rather than the non-verbal communication skills, because non-verbal also meaning by the eye contact, body language, it is a complete big topic to be dealt with, and I think it's a topic for another day. So thereby my presentation. Right. So whenever we are going to talk about communication, communication is of two types. It's verbal, as to how we speak, and then there is non-verbal. So as I said, non-verbal involves a lot of things like eye contact. So when I'm sitting across somebody, well, it does, diffuse a bit when you are doing online mediation, but it still helps. So when I hear you say something and I nod, it means I'm listening to you. So I'm not saying anything, or I'm not speaking up, but I'm still reflecting my answer and my understanding. So this is the kind of communication that I'm talking about, right? If I am constantly, twitching my hand and, looking at my watch and trying to see the time, it means probably, I am not concentrating. So these are the small cues and the body language, which does come a lot into play when you are in a mediation room. So as a mediator, your task is to really observe and understand what the parties or the advocates which are with the parties trying to communicate to you. And also as parties and mediating advocates, you need to understand that whether the other party is actually listening to or not, if I am going to go ahead or not. So the body skills really, really make a lot of difference. But verbal skills nonetheless impose more. So my today's thing is for the verbal skills. So when I talk about verbal basically has two things. So A, it is the tone, and B, it is the language as to what we are speaking. When we talk about tone is extremely important. For example, if I say that, I'll just take an example in the instance that it was a pleasure to be here, right? That is one way of saying. I use the same language and I say, being here. So you get in my tone, there is next one. So probably one might conclude that it wasn't a really fun or a good experience from me. I'm saying and using the same words, but what is changing is my tone, which makes all the difference. So when you're sitting across tables in a mediation setup, your tone is really, really important, because if you get too aggressive with your tone, if your voice suddenly increases, the volume increases, the pitch changes, automatically it infers that the other person is not, you're trying to be angry. Even if you're not using those words, you're still showing your anger in it. And then, of course, well, it's always easier to say it, that you use better language when you are not a part of the dispute and when you are there as a third party. But when you are sitting as a mediator, when you are inside the room, involved, not in the dispute, but involved in the process, and as the parties, when you're involved within the dispute, it is very difficult to keep a hold of the language after a point. So these are the things which are very important to maintain when you are actually wanting to have a successful mediation process. Now, so there are 7 C's of effective communication, right? So when you are trying to communicate something, these are a couple of things which are extremely important. Concreteness. So whatever you say has to be extremely concrete. Like you can't go around it, round and round. I'm sorry for the slight timing. So it has to be concrete. You can't go around it in a vague manner, encircling what you're trying to say rather than actually bringing up what you want to say. Then correctness. Correctness basically means you are trying to state something which at least you know is correct. I'm not saying that there needs to be a factual understanding of correctness here. Just a minute, I'll just try to, yes, probably that will stop the slide change. So yes, correctness is important according to your understanding. Then it comes to courtesy. Courtesy is extremely important. A lot of times, normal psychological condition, because you're undergoing a dispute, you're trying to resolve something, you're not in your usual best self. Courtesy takes a backseat, but we have to understand that whenever you're trying to communicate and you want it to be effective, courtesy is very, very important. You have to greet the person. You have to be in a manner that the person actually ends up listening to you and doesn't feel very defensive in the manner of listening to you. Then completeness. Completeness is also very important. Sometimes we leave things halfway down the lane. Okay, we are trying to say something, but we are just brooding over it so much, on and on and on, that we end up not completing what we are trying to say. Then of course, there is clarity. By clarity, a lot of things come into play. So sometimes it is how you speak. It is also your accent sometimes. So you can't just always have a very fancy accent to make yourself, showy. But in doing so, you're actually not clear to the person. So that is extremely important, to have the clarity while you are communicating. Then you need to have consciousness. Consciousness is a very, very important part to play. You are sometimes in the fit anger, or you are in a situation where you don't know how to handle, you're completely frustrated or anxious or impatient, and you end up saying things which are not consciously to be said, something which is at the back of the mind, something which is not related to the matter, but something comes around. An easy example would be when you take out your frustration on one of your friends because you had a bad day at work or something like that, right? So that is extremely important to have an effective communication. And you have to always understand that whatever you are trying to communicate, you have to give that space and effect for the other person to consider that. You have to be considerate about the fact that there is another person involved with his or her own perspective, idea, and it's going to take some time to seep in. Right? So moving on to the next. Right. So now what happens in a mediation room? We have, let's say, 5 people. So there's the mediator, there is disputant A, and there's an advocate for disputant A. And then you have disputant B, and there's an advocate for disputant B. Now, when you want to start a conversation, it has to be made in an orderly fashion, and you have to wait for your chance to speak. If everyone starts speaking together, this is what is going to happen. A chaos is supposed to get created, and nobody will actually be heard, and nobody will feel that they have been heard. So it's going to just create further agony and further impatience and distrust over the process. So as a mediator and also as participating advocates, if I have to say, because I cannot really, I hope that one day we can train everybody so that even the parties who are coming for mediation know. But at least as advocates and mediators who are getting trained currently, we need to understand we have to wait for a chance to speak, even if you are completely triggered and you know that the other person is presenting something which is factually incorrect, and you have something to counter that. You still have to wait for your chance to speak. That orderly fashion of conversation is extremely important. Now, what happens for a communication in mediation? Now, mediator is basically a transmitter and a receiver, right? And then you have a disputant who also is a transmitter and receiver, and so does everybody else, right? So in a mediation setup, we are both transmitting information and we are also receiving information. So we are on both the sides of the loop, everybody in the room. Now, what happens during that transmission? So when I'm trying to say something to So, what are these barriers, if I have to say? So, when the sender, let's say the disputant is addressing the mediator, so the sender becomes the disputant and the receiver is the mediator. Now, these are the certain barriers of conversation. So, there is lack of knowledge about the message, right? So, the sender is trying to say something, but is not very sure as to what they are trying to bring up. Then there is jargon issue. Jargon issue is basically terminologies and words which a certain set of people are used to. For example, you have current teenagers when they are, texting or writing an email. So they use certain jargons. For example, there is LOL, which means laugh out loud. So if somebody is sitting there who is a teenager in a dispute or someone like that, and when that person says LOL, I'm sure half of us wouldn't even understand. So there are jargon problems. Or let's say somebody from a medical background is sitting there and refers to something about the ECG, and so we will be stuck there. So there is that problem always. Then there is the volume of voice. So how you modulate your voice is extremely important when you're trying to communicate. Sometimes if your voice is too high, what the other person hears are not the words, but the voice and the pitch at which you are throwing the words at. So it is extremely important. So this also becomes a barrier in communication. Then age difference. Age difference is a very cultural thing. So if you talk about Southeast Asia, like at least India, Bangladesh, we always have been taught, that if somebody is elder to you, even if the other person is wrong, you're not supposed to react, or you're not supposed to say that on the face of it. So sometimes when you're in a dispute and somebody who is very well mannered or had been taught and brought up in such a manner, that person will find it very difficult to constantly oppose somebody on the who is much older than the person himself or herself. So that thing also comes as a barrier to communication, because you're not able to communicate because you think that the other person is elder or younger in whichever manner, right? Then there is different political views. It does play a part in very few critical. So if you're talking about mediation in an international level, of course, political views do come in as a barrier. Then you have a boring message, okay? So that's when you're constantly speaking and, you don't know where to stop. You're being given a chance, but, you're constantly going on and on and on about that. So that you have to understand that everybody has got a very limited span of attention. So you have to end your message like that. You cannot. So what happens is after a point when people lose their attention span, they stop listening. So there is no message being received. Then you have different religions, of course. So certain religions have to catch. So that is something which also becomes a barrier. Then there's an emotional state. Let's say I had a very bad day since the morning and I have this very important presentation to make, and I'm in a very bad emotional state. So, even if I'm trying to communicate something, at the back of the mind, I'm not in the correct space, which is why I'm not able to send across the right message. Then there is disability. Disability whereby it could be physical or psychological disability. Then there is unwillingness to listen. You just want to speak, you don't want to listen, right? And there is a verbal message which is different from a non-verbal message. So, for example, I am, let's say, somebody speaking up and I'm sitting right in front of them. And when they're speaking, I'm like, sitting like this, and I'm doing all these actions, and I'm saying, yeah. So my body language says that I'm not interested, but on the face of it, with my language, I'm saying, yes, go on. So that difference also creates a lot of confusion, and in that manner creates barrier in communication. So, of course, there's noise, there is lack of planning. So in mediation, it is always said, when you walk into a mediation room, you should have a prepared opening statement. You should have a flow of thought written down as to how you want to take that conversation ahead, so that you have things planned and it's not just extremely random and distorted. Then there are wrong and unclarified assumptions. Then there are semantic problems, cultural barriers. It's a very interesting thing when it comes to mediation. I could quote one example. I was working in Auckland in a law firm, and we had a dispute regarding we had a workplace dispute basically. So there was this lady who was from China, and she was working as a personal assistant to one of the law firm partners, and the law firm partners was He was a man of about, say, 55 to 60 years from Britain. So there was a workplace difficulty going on, and it was brought down for mediation. So when the mediation started, the lady just couldn't speak anything. So what happened ultimately? The mediation dissolved because nothing could be drawn out of it, because the lady wasn't ready to speak. She was not feeling fine and everything. So later on, when we asked her personally what went wrong, she said that, I'm not comfortable speaking to a man of that age in our town, in our city. We generally don't talk to them like that, and I'm not very comfortable discussing certain matters in front of him. So there are such cultural barriers as well. And then, well, that got resolved because that was taken around in a caucus session, because we got to understand that the lady, and that is where the caucus session helps in. She said so, and then it was arranged by the mediator in a manner that she does not have to address it directly, but the mediator took in the step for her and brought that matter out. And then finally, after a few days, that matter got resolved. So that's how cultural barriers, come in. Then you have socio-psychological emotions, filtering. A lot of filtering happens. Sometimes even while reading the slide, I'm thinking that this is not important. Let me just skip it and let me get to the important part. But maybe what I'm not understanding is maybe what I'm skipping is the important part. So that's there. Then information is sometimes overloaded. There's poor retention. People don't remember what you're saying. So in a mediation setup, what you started off with and what you ended with are on completely different tangents because it's so haywire. Then there are goal conflicts, of course. That's the important thing. And offensive style. Somebody who's got a very rowdy style. On the contrary, other one is supposedly very sophisticated. So in such a manner, there ought to be certain things. This experience I had when I was in National Law School. So we were doing consumer disputes, and we had a dispute of a consumer from a small village with Amazon. So we got the two parties in, and when Amazon came in, the villager was sitting in his dhoti, and he did not know how to sit on the chair. So he was sitting with his legs pulled up. So the moment the Amazon manager came in, he was like, "What is this? I'm not going to talk to this man." So well, that also took a turn and was dissolved accordingly. But these are things that a mediator faces right on. Okay, so one has to be ready to understand and probably a proper understanding of a person, or before the mediation starts, you can have individual sessions with both the parties. It's called pre-mediation counseling. They used to do it. Some firms used to do it back in New Zealand. So it's a very effective method. You understand what the disputant is coming from, and you also understand that and then you have abstracting and inferring. So sometimes a lot of ends up concluding something completely off the track, which is not supposed to be concluded at that very point. So these are in total a lot of barriers which we have to successfully bridge through to create an effective communication skill set in a mediation setup. So these communication barriers have been divided in a couple of topics, and these are the important ones that I felt should be shared. So there's a cognitive dissonance. So what happens is when you're trying to send across a message to someone else, that person receives the message but does not understand how to respond to it. For example, a sender tells a chain smoker that smoking is dangerous for health, right? So the receiver accepts it as a truth, but due to his habit, he fails to react accordingly. So he doesn't quit smoking because he's so habituated to it. So this is where the cognitive dissonance comes in, right? Then there's a technical semantics and jargon that we talked about. There are abbreviations and there are phases and terms which are used by a particular group of people as experts, or which we call lingo. So if I speak Bengali in Calcutta and if I speak Bengali in Dhaka, it's going to be certain words are going to be very different. So maybe I don't understand those words there, or people from Dhaka might not understand the Bengali that I'm speaking. So these are the lingo problems that come across as well. Then there is advocacy bias. Advocacy bias is something which is very specific to us lawyers. So what happens whenever we get into such a situation, even as a mediator or as a mediating advocate, find similarity with some old, and we include what the conversation that do that. It is I understand it is very difficult. Even I face that, and I'm sure all of us who have done advocacy, has faced it. Probably 1% or 10%, but do face it. So then, what we have to do is we have to stop there, and we have to understand that we are not here to advocate our skills, or to put up our advocacy skills, but to resolve something. So if you are a mediator, if you are in the mediator's shoes, you have to be neutral. And if you are in the advocating mediator's shoes, you have to understand that I'll have to help my client resolve the dispute through the mediation, and not think that, oh, the other party is definitely going to lose in the court. Let us, finish off this mediation and then let's go to court because you're going to win this. So that kind of barrier does come a lot. Then we have assimilation bias. Okay, so it's a very common one. It's like, whatever we want to hear or whatever we hear, we actually translate it into something we want to hear. Right? So, for example, I am a big fan of chocolates. Okay, so sometimes my mother would just say that, I have read somewhere that chocolate is good for your brain. So automatically, I just presume that she's trying to say that, it's okay for you to have so many chocolates, and I start, so basically the point being very simple, that I am hearing what I want to hear. No matter what you say, I have to conclude it according to my will and my desire. Right? Then there is endowment effect. So what happens with endowment effect is, let's say you possess something. Let's say I have a home, okay, and the market value for that home is, let's say, just 1 lakh. But since I have grown up in that house, and my parents grew up in that house, and I have lots of memories around there. So for me, that house values 20 lakhs, whereas the market value is actually 1 lakh. So when I'm trying to, let's say there's a dispute regarding an agreement where I'm selling the house and something like that. So when it comes to that, I'm always overvaluing my asset. This is called an endowment effect. This also becomes a huge problem while communicating for mediation. Then there's a certainty bias. It's like there's a hunch or a sixth sense, we call, and you're like, I'm sure this is how it's going to happen. So you start basing your decisions and facts and statements on that. And then, of course, we have the egocentric bias, where your ego stands up way higher than that. And that comes into play more so when in litigation. There's a saying in Hindi which says, which basically means, if I drown, I'm going to make you drown too. So let's drown together. It's like that, okay? So that's where that ego part comes into play, and you think that your opinion is way more important and higher than someone else's opinion, and that absolutely hinders any positive communication or conversion of the dispute through the mediation process. Absolutely. Right? Please stop me if I am taking more than my time, right? So what are the barriers from a sender's perspective? So when you are a sender, what are the possible barriers that you will have? So you probably have a lack of planning and vagueness of purpose. You are not very sure of what you're trying to achieve. You just want it to get resolved, or you want to have everything that you desire, but you're not understanding where to draw that middle line. Then the objectives to be achieved, then the choice of wrong language, and there are certain assumptions which you have not shared, but in your head you're already assuming such things. For example, you're already assuming that the person on the other end is going to lie, right? So you are already making such an assumption, and you are communicating based on that. For example, if there is A on the other side of the table, and I'm B on the other side, we are in a mediation, and I presume that A is always going to lie. So whatever I end up saying, I say, for example, I know you have the car, but I know you are never going to accept because you will lie. So it's okay. Let's not talk about it, or let's discuss about the other thing. Let's not get into this. So such presumptions. Then there is different perception of reality. Well, perception is a big topic. In the most crisp manner, if I have to say, everybody sees the world through their own eyes. What happens with that is they see, probably two people might see the same thing in a different manner. Okay, yeah, I'm not sure if you have seen that picture. There's a rabbit and a swan, or there are many such pictures which are available, where from one end you can see one picture and from the other end you can see another picture. That is called perspective. I mean, an easier way to understand perspective. So everybody has got different perspective and presumptions of reality. So something is a fact for me, and something else is a fact for you. But these are both facts and reality for us. So that's that. And then, of course, there's a wrong choice of channel. For example, channel means whether you're trying to speak or you're trying to write a mail or a letter, or you're just trying to pass a chit during mediation. So what happens? That channel is not the right one. And then as a receiver, when you are on the listening end of it, this was when you were speaking. This is when you are listening. So you are a poor listener. You are inattentive. You do not trust the person. So you're like, yeah, you are going to blabber, I'm going to listen. I know you're not going to tell the truth. So that kind of an attitude is there. Then you have lack of interest. You are not interested in listening. You have a premature evolution. So basically what happens with that is you have a certain conclusion drawn in your brain, and let's say the other person is trying to explain something, but you don't want to listen to that explanation. And even a part of that conversation which leads to the conclusion that you have in your head, you're like, yes, now I have already evaluated you, I don't want to listen to this further. Then there are semantic difficulties, there's bias, lack of trust, then there is different perception, of course, that also comes into place, and there is attitudinal clash. So somebody, as I said, somebody is coming up, somebody, let's say, is very rowdy, or people from Haryana, I'm not sure if you have heard, but they have got a very rude tone, and they always so in Bengali, if I have to say, they always call people in tui. So they will even call the elders in words of tu ya tui. So they never call aap or apni. They don't use words, but that's how they speak. Okay. So for them, if they come across somebody who is from, let's say, Karnataka or Bangalore, where people are very, very mannered, they will never, probably for people of their same age, they will not use such words. They'll use aap or apni. For them, it will be like, oh my God, this person is so rude and, has so much of attitude. So these kind of things come into play a lot. And of course, then if the other person is not what are the listening problems? Okay, what happens when you are, what are the barriers, if I have to say, to listening? Okay, there is discriminative listening. So what happens with discriminative listening is you try and interpret and assign meaning to the sound rather than words. For example, you are more, focused on the pitch and the volume, but you're not understanding. So that is listening is very, you just want to listen. You're just trying to, figure out what is wrong with that. So you're just being a critic while listening. Then you could be a biased listener. Biased listener is when they just want to, distort what they're listening into the facts that is easy for them. I just want to hear what I think is good for my cause. So I'm biasing whatever you're saying. It's biased towards what I want to hear. Okay. Then you have evaluative listening. Evaluative is very similar to critical listening as well, but it's like you're trying to judge someone else and evaluate what they're trying to say. Like, rather than listening to them, you are just wanting to, score them. Then there is appreciative listening. Appreciative listening is like, for example, you're listening to a music. You listen to a music to mostly appreciate. Okay. So your entire goal to listen is to say good words and to appreciate the thing that you're listening. Okay. But not analyze or process it in any other possible manner. Right. Then you have sympathetic listening. Sympathetic listening is like, it's a very emotionally emotionally driven. So let's say you are a mediator and you're sitting across two people, and there's a woman who has come across with charges of domestic violence against her, and it's mental domestic violence, and you are a woman, and there's the man sitting on the other end and saying that no, this is not what has happened, you misinterpreted, to the woman, of course, the other disputant. But you as a woman, somewhere you start feeling that, oh my god, no, this is really bad, women are always mistreated. So you start becoming a sympathetic listener. Okay, you're sympathizing with the other person, and that doesn't really lead to a very neutral listening standard, if I have to say. Then empathetic listening is also there. Well, empathetic listening is actually a good thing. Empathy basically means you're trying to put yourselves in another's shoes, and you're trying to understand what the person is going through. You're trying to rephrase that person's idea, and you're trying to understand where that person comes from. It is different from sympathy. In sympathy is more of like, you're feeling bad for that person, okay, and you just want to, it's like, out of sympathy you could probably do charity. Out of empathy you can actually go and help the person, and and put up with the person. So that's the difference. It's a very thin line drawn, but sympathy is not very good, and empathy is exactly what we are looking for. And then you have dialogic listening, where the idea is basically, it's like you are trying to learn from the conversation. So while hearing, you're trying to pick up information, and you're trying to learn facts. For example, if you're trying to deceive somebody in a mediation, you just want to get into a mediation session with a disputant to gather information. So the mediator has to catch and understand whether the party is actually wanting to mediate and resolve the dispute, or is just here to gather facts. So this is all very tricky, and it overlaps a lot, but these are really important actually to end up having a very successful mediation. Well, just to summarize, listening basically means you have to be active listener. You have to understand. Okay, listening doesn't really mean you just hearing something. You hear the noise, you hear the car on the street and the dogs out in the park. You hear them. You don't listen to them. Listening is very much more active. Okay, listening is something which you take inside and you process. And active listening is when you take inside, process, and react accordingly. So if somebody's talking to you, you are not just sitting there blankly listening. You're also nodding your head and showing signs or saying So you make sure that the other person knows that you are actively listening, right? And a holistic communication is extremely important. And of course, active participation is something which we cannot do without, and it has to be from both the person who is receiving the message and the one who is sending it. And listening involves both physical and psychological effects. Okay? You have to understand that when you start listening to the other party starts putting their trust in you. They understand that, okay, this person is probably trying to understand where I come from. And that actually eases the dispute way more than we can actually imagine. Well, while listening, if you are sympathetic, you are going to compromise the neutrality, as I gave the example. The listener becomes the part of the problem. Okay, so because if I am sympathetic, I start taking side of one disputant, and that creates a problem in the balance. And there is loss of objectivity, of course. And then you get back into your own past because you're trying to relate that same experience in yourself, that, oh, I also went through this and all. So you cannot be a sympathetic listener. As a mediator, you just cannot be. As an advocate, you still probably could be, that could still be minutely excused, but as a mediator, it cannot be excused. Empathy, it builds trust, and the listener actually helps focus into the problem. The objective is extremely clear, and it is much more futuristic. When you're listening, you're trying to, look towards the future rather than going in the past and, brooding over it. So empathy builds respect and trust, and it helps in problem solving. I'll just go fast. I don't want to take much of time. We've already talked about this. So what does empathetic listening involve? Willingness to let the other parties dominate the discussion, right? You have to let the other party dominate that conversation for some time so that the other person understands you're trying to fit into their shoes. Attentiveness to what is being said, care not to interrupt. It is extremely important. You cannot interrupt. What you can do once the other person stops, you can ask open-ended questions. Okay, something which is not like, would you like an apple or an orange? You will not like. You would probably ask a question like, if you want a fruit, what would that be? Right? So it's an open-ended question. Then you have to be sensitive towards the emotions expressed. Let's say somebody's trying to express and starts crying. You can't be all tacky about it. Oh my God, why are you crying? Not like that. You have to empathize with the other person, understand the person could be emotional, okay? And the ability to reflect back to the other party. So what happens when disputant A speaks something, the mediator has to understand that with empathy, listen to it with empathy, rephrase and reframe it, and put it around for the disputed B to understand that better, right? And you have to acknowledge the speaker, increase the speaker's self-esteem and confidence. If you have a place where there's a cultural difference and you understand that this lady is not very comfortable speaking or not comfortable at all speaking, so you have to constantly boost her confidence. You ask her, you keep asking her, because you know that she's going to be behind, right? And you have to tell the speaker that you are important and you know that you are a neutral. You're not going to judge anybody, and you have to gain the speaker's cooperation, and you have to make it seem like a teamwork, right? Well, we have discussed this. What are the reasons? So a couple of giveaways is when you are in a mediation as a mediator, more so, please try and be attentive and interested. You have to be interested. That is where the difference does kick in. If you're just there for the sake of it, because I have seen a lot of court annexed mediations happening, which are not mediation at all. They're just somebody sitting in the middle and just saying, okay, what is your problem? What is your problem? Why don't you just solve it? Get done with it. Why don't you understand? You know, like that. So it shows you're not interested at all. You just want to get rid of it. Don't be that. Okay. Be interested in it, be alert and not distracted. Don't have your cell phone ringing in the middle of it, and a peon coming in and telling you something. Don't do that. Okay, create a positive atmosphere. Be a sounding board. It's basically like you have to let the other person feel that whatever idea and feelings you are trying to that person is trying to give, you resonating the same. Okay, don't ask too many questions. Okay, I mean, it shouldn't come across for any of the disputant that you are constantly trying to ask questions to take out information or probably bully the person. Okay, don't do that. Act like a mirror. And in case you're stuck where the other person is not in a very good space, headspace, you can reassure that person that it's okay. It's not that bad. Maybe today wasn't a good day, but he'll get better. That you have to reassure. You have to create a very positive space, which is extremely important for mediation to work. And when you're trying to invite somebody, I think you can always call upon the person. You can clear this right before the mediation starts. That kindly please let me know how shall I address you. Should I address you as Mr. A or just as A or A sir? How do you want me to address you? So get those things corrected and try and address the person, and try to have that person speak up their mind. Okay. Well, a couple of active listening skills that should be developed is you need to analyze and evaluate speeches in your spare time. So once you're done with the mediation, you could go back and reflect, phrase or reframe those sentences better, and think better ways to make the environment comfortable and more friendly to be able to resolve it. Rephrase and summarize the speaker's ideas. Yes, of course. It is always healthy to have a whiteboard at the back where you can keep jotting on the permission of the disputants, of course, or you can have a notebook and you can take permission from the disputants whether you can make those notes or not. So these are very important, okay? And please avoid distraction at any cost. Looking at the clock, looking at who is crossing the window, or if somebody is knocking the door, or there's a problem in the chair, or the table is making noise. These are not things that you want to do while you are mediating. Well, one thing it is extremely important that as a mediator, one has to be very, very calm. Sometimes there are mediations which go on and on and on about the same thing. You thought that the mediation will get over in 2 hours, but it took the entire day. Let's say you had a party planned in the evening and you really want to go there, but you know that if you stay for 3 more hours, this mediation will get resolved. Stay. Be calm. Please try and understand that you have to do that. Sometimes it really becomes frustrating. There has been a mediation I saw where the disputants had laid down their issues, and the second issue. Well, this is it. That should be all from my end. Thank you so much for being such patient listeners. Please do let me know if you want to discuss something at length. I hope I have been able to share something which can add or at least rebrush the skill set in everybody's pocket. So thank you so much. Have a wonderful day ahead. Thank you so much, Goswami sir, for creating this space and giving me the platform. And I'm really delighted to be a part of this event. Thank you so much. Thank you, Sylvia.
Thank you, Ma'am Priyanka Chakraborty, for helping us become more aware of the problems of communications and the ways we can help solve them. We hope you will consent to speak to us again. Thank you so much. Moving to our next guest speaker, Madam Tanushri Roy. She is an advocate and certified mediator from International Mediation Institute and also the faculty member of Bangladesh International Mediation Society. Ma'am, your time is allotted for 30 minutes. Madam Tanushri Roy, we are not able to hear you. We cannot hear you. Can you replug again? Okay, you're muted now. No, you're not audible. Can you hear us? Okay, but we are not able to hear you.
I think try going out and coming back in and join with your computer speaker and microphone.
Good morning. Am I audible now?
Yes.
Yes, we can hear you.
All right. Just a moment. Good morning, everybody. Good afternoon, everybody. At the outset, I would like to apologize for this delay and technical glitch. I thank Ms. Sylvia for that wonderful introduction.
And Didi, she's she's joining us.
Yes, thank you. I thank Sylvia for that introduction. I am Tanushree Roy, an advocate, a mediator, and classical dancer from India. At the outset, I would like to express my deep felt gratitude to the Bangladesh International Mediation Society for having invited me as a guest speaker at this virtual conference being organized at Rangpur in Bangladesh. I offer my heartfelt greetings to Honorable Justice Iman Ali, the chief guest of today's conference, as well as Lady Justice Joyce Eluch, the keynote speaker. I offer my sincere salutations to all the members of the bar, the bench, my dear colleagues and friends of the legal fraternity, mediators, and other members of the civil society present here today. My talk today here is not going to elaborate on the technicalities of mediation, which has already been beautifully elucidated by the other honorable speakers today, but is basically going to touch upon the different legends and myths that that influence us, and taking inspiration for them, I would try to bring forth the basic essence and the basic spirit that mediation brings to us, and the role that mediation can play in resolving disputes and bringing about a more peaceful world order. So without further ado, I would like to begin. History is replete with immemorable examples where different people have taken up pertinent roles as mediators in different points of times. One such instance is the story of the Mahabharata. This is a story from Indian mythology, and I would like to briefly talk about the same for those who have not heard of the same before. The Mahabharata is the story of two sets of cousins, the Kauravas, who are 100 brothers, and the Pandavas, who are 5 in number. Now, both these sets of cousins have certain rights to the lands and to ruling the same. However, the Kauravas are extremely unrelenting and selfish, and do not want to give their cousin brothers, the Pandavas, their share of the land or property or governance. So what this ends in is in the war of the Kurukshetra, which lasts for more than 18 days, bringing casualties to both the sides. What is interesting here is the role of Lord Krishna, somebody who's considered as a god in Indian mythology. However, who actually takes up the role as a peace builder, as a negotiator, and tries to mediate peace between both the parties. However, as mentioned, the Kauravas are extremely unrelenting and refuse to give up their share, resulting in their ultimate doom. So what is that? What are the key lessons that we can learn from this particular example? Number one is that the fact that a god himself would be willing to take up the role of a mediator attributes some form of positive divinity to the concept of mediation in itself. Secondly, the fact that the Kauravas were unrelenting and ultimately failed tells us that those who are averse to transformation, those who are averse to positive change, those who do not want to engage in sharing and collaboration, those who are averse to an environment of kindness and an environment of compassion, never really achieve solace and ultimately end up cutting their own feet. And thirdly is that mediations may fail. If a god could fail as a mediator, so can you and I. But does that mean mediation as a concept or mediation as a process has failed? Definitely not, because it's Much better to have tried and failed, but to have never tried at all. And what better example of this than the process of mediation? So mediation should never be seen only as an end. We should not judge a mediation just by what the outcome is or whether we can get a positive settlement. We may not. But just the process of getting two parties to sit across each other to discuss their perspectives, discuss their problems, their views, may actually help us clean many cobwebs in the form of internal grudges, in the form of preconceived notions or miscommunications, which may be bringing the parties down, and may actually lay ground for a purposeful future of mutual collaboration or kind of positive value addition, mutual value addition to each other, leading to better relationships, hence a better future. So mediation can never fail. Even if we don't achieve a settlement, that doesn't mean that mediation as a concept or mediation as a process has failed. But what is another thing that we get from this is that as mediators, we often have to deal with uncertainty. We don't have statutes particularly governing our outcomes or our decisions. It is a self-determining process, hugely based on the parties. But as a mediator, we need to have the people skills to be able to deal with the beliefs, the value systems of people and facilitate the process to the best of our ability. Now, moving forth, my next example comes from a very famous Indian author called Munshi Premchand, who has discussed the concept of justice in his work, The Panch Parmeshwar. Here, as also talked about by Justice Ahmed, is the concept of the Panchayat, which is the basic go-to authority for all kinds of problems or dispute resolution at the grassroots level in rural India. So as in this case, the jury of this panchayat comprised of a person who had a personal grudge against one of the disputing parties before them. And more so, that person wanted to take out that personal grudge while delivering justice to those parties. But what eventually ended up happening is that the entire jury, and particularly that judge, ended up giving a very equitable and a very just solution and a very just outcome to the parties. So, I have not, due to paucity of time, I will not elaborate on the story. But what is the takeaway from this? The takeaway could be that humans may be biased, they may be unjust, they may be vindictive, they may be vengeful. But often when given the opportunity of exercising the spirit of justice, equity, and good faith, and when given the opportunity of bringing someone to positive justice, and when given that role or that responsibility and that environment to be able to do that, the outcome may actually be very different and may bring out the innate goodness in us as people and particularly us as mediators. Now, moving forth to another example, which may talk a little bit about the nature of a mediator or the characteristics that a mediator could have. A very simple story between Zeus and Hera, who are regarded as the Roman king and queen of the gods. Both of them fell into a particular dispute regarding a personal matter, and they didn't know what to do about it. So they went to a person called Tiresias to resolve the disputes. Now, an interesting thing would be that what would a person really have? What would a mediator need to have to be able to resolve a dispute between the king and queen of the gods themselves? It ended up being that Tiresias, because of his multifarious experiences that he had had and the diversity of perspectives that he had come across, actually was a very, very holistic human being who didn't see things at an individual level, but could kind of relate it to the larger picture, to a wholesome unit. And at the same time, be extremely impartial, be extremely fair, be extremely just, and be extremely detached to the process of mediation, despite, irrespective of whoever the people were in front of them. So this is the basic thing that we need to learn, that as mediators, it is important to expand our experiences to get to be able to understand as many perspectives as possible. Yes, as Ms. Priyanka said, to put ourselves in the other person's shoes and to exercise empathy, but at the same time, remember our role as neutral third-party facilitators and being extremely fair and impartial in that particular process. Now, coming to another example, and here I'm going to talk a little bit about the nature of conflicts. What are conflicts but some kind of unbottled or some kind of bottled up or suppressed emotions or grudges or some negativity that we have bottled in? And often it's submerged in these kind of preconceived notions, in these kind of miscommunication and false attributes that we give to other people, which prevents us from even entering an environment which is conducive to change, let alone transformation. So here I'm going to talk about the story of the Sagar Manthan, again a legend or from Indian mythology, which is basically about the churning of an ocean by the gods and the demons, using a mountain as the pivot and a great serpent called Vasuki as the rope. So what they really wanted to do is to churn the ocean in order to get the best of what the ocean had to offer them and to share it between the demons and the gods. But despite all their efforts, what ended up happening is that at the first instance, what came up was not some kind of miraculous, chemical or some miraculous power, but it was basically poison. Poison which was lethal enough to destroy the gods, the demons, as well as the entire mankind and the world, all the worlds at once. So the gods and demons didn't know what to do about it. And there is where Lord Shiva came, who is again a god from Indian mythology, and he drank the poison for them, saving both the parties as well as all the worlds from doom. So, how does this relate to conflicts? Like I said, conflicts are nothing than that bottled up poison inside us, and which needs that kind of churning, which the mediation process provides us, that kind of conducive environment for us to, number one, have those conversations, to be able to share our perspectives, to be able to bring to the table, to lay bare on whatever communication gaps we have and to move towards resolving our disputes. And it is only when this poison comes out that we have that environment conducive to these positive conversations, which can further lead to mutually reinforcing solutions. So, like I said, that our lives may be full of conflicts, but we have to take to processes such as mediation to bring out that poison from inside us, because once that comes out, the potential of bliss, the potential of getting that amrit or nectar of life is. Another thing is in this process, the mediator who plays the role of this neutral third-party facilitator, despite having, like I said, needs to have that kind of holistic perspective towards life, but at the same time be impartial. That is, we as mediators may have to close our eyes or to semi-close our eyes like the Lady of Justice and not let our own preconceived notions and attributes affect the process. So mediators in a certain way have to bring the attention of both the parties to a form of conscious awareness, which goes beyond personal interest and brings to the parties that potential of eternal resolution. And thus mediation as a process may provide that opportunity to parties to clarify their own internal goals and choices for themselves and get a clearer understanding of the other person's perspective. So though I'll just talk a little bit about mediation because I want to relate it to how it can further lead to a better world order. And this is something which all my honorable speakers have talked about in detail, so I will not talk about it in detail, is that mediation, by being a self-determining process, by being this open, this fair, voluntary, time and money saving, resource saving process, driven by confidentiality, driven by this sense of with this neutral third facilitator, is nothing but the potential, is nothing but an option for us to move away from disturbance, to move away from conflict, to move away from destruction and turbulence and move towards productivity, towards prosperity. And, it gives us that channel, like once that conversation gets going, it gives us that channel of, using our creativity, coming out with innovative and creative solutions, adding value to each other's lives, to our work, and most importantly, strengthening human relationships in that process. And like we know, like I'm going to relate this further to another Indian concept of Vasudeva Kutumbakam, which is that we're all one earth, one family, and one humankind. But before that, we know that mediation, there are no second thoughts, that mediation is applicable to a variety of contexts, be it at our workplace, be it at home, in our personal relationships. At the workplace also, it can be divided, it can be applicable to the corporate sector. You can apply it to the civil sector, to commercial disputes, to the social sectors, even at home. But also, most importantly, at an international platform, particularly as a tool to bringing out better bilateral relationships between people. And here again is when the role of the mediator becomes very important. And as Ms. Priyanka talked about the importance of different ways of communicating, to be able to understand cultural relativity and mold ourselves in a way to be able to do that is also very important. And I'd also written about this in an article that I published earlier. So further elaborating now on the concept of Vasudeva Kutumbakam, we need to realize that as mediators or as potential mediators or mediations or students of mediation, that in a world today which is divided into differences of caste, of class, religion, ethnicity, color, race, we don't need any more divisions. We don't need any more conflicts. What we need is that catalyst which can unify us, which can solidify us, which can bring us together in this kind of unity so that we can work together towards common goals. And when is this more important than in today's context, such as that of a pandemic, where we all really need to put our differences behind and move together in unison towards reaching collective solutions to common problems. And at this juncture, I would also like to share some observations of His Holiness, the Dalai Lama, who does not view conflicts as a problem, but as an opportunity for future growth. And I'll just quote one of his observations. I quote, "Now, there are many, many people in the world, but relatively few with whom we interact, and even fewer who cause us any problems. So, when you come across such a chance of practicing patience and tolerance, you should treat it with gratitude. It is rare, just as having found a treasure in your own house. You should be happy and grateful to your enemy for providing that precious opportunity." Unquote. So basically, we should not see conflicts as a problem, differences as a threat. We should see them as possibilities of clearing out whatever cobwebs we've had and move towards mutual growth. And nothing sums up the role of the mediator as a catalyst better than facilitating this process of converting conflicts from a cause of, or from being regarded as a problem, and making conflicts actually look as possibilities of solutions. So, moving forth, even the Bible says that blessed are the peacemakers, for they shall be mediators. But this peaceful attitude, they also become peace themselves. Nothing more can really end today and better world order. What I'd like to say is that let us envision of looking at disputes, life, of seeking a better world order. And it is very heartening today to see different international conventions, such as the Singapore Convention coming up, various countries are coming up with national and regional for media. Even the judges, there are so many people from the bench as fans. I'm seeing a lot of judges encouraging mediation as the first option in their orders in the courts, and thus reaches institution a first step towards actually making to go. And as lawyers, as members of the civil society, must on an everyday basis try to promote mediation in whatever way we can. And I would like to congratulate the Bangladesh International Mediation Society for its efforts at organizing such conference, a wedding, which is extremely important. Engage in such activities. The future generations, the youth will never, will not. We need to play a very main catalyzing role so that we can get our future generations to follow in our footsteps and to take the movement to all its glory. So in this court mediation at every level, peer mediation needs to be encouraged at the school level. Mediation should be taught as a standalone subject in law colleges and not as a subsidiary subject in our alternate dispute resolution courses. And another thing that I'd like to say as a lawyer is that we must never this is something, a personal experience which I faced with some of my lawyer friends, is that they don't take too kindly to mediation because there is this presumption that it's probably taking away their bread and butter. But I'd just like to tell them that as long as humans exist, conflicts are nowhere to go. So there's no threat to your bread and butter. However, if we can help people resolve their conflicts in a more amicable manner, and we can make we can really change the legal ecosystem, which is our justice dispensation system is already overburdened. And if we as lawyers, as legal ambassadors and mediators can help change the way we look at disputes, we can really come forth with a very different kind of outcome. At this juncture, I would also like to share something which I had written in another context, but which very beautifully elaborates on the need of a more peaceful way of resolving disputes and truly achieving the spirit of Vasudhaiva Kutumbakam, or One Earth, One Family. And I will quote from my article, quote, "We must recognize that in the midst of a magnificent diversity of cultures and life forms, we are one human family and one earth community with a common destiny. Vasudhaiva Kutumbakam, or One Earth, One Family, should be our mantra. The emergence of a global civil society is creating new opportunities to build a democratic and humane world. Our economic, political, social, and spiritual challenges are interconnected, and together we can forge inclusive solutions. We must join hands to bring forth a sustainable global society founded on respect for nature, universal human rights, economic justice, and a culture of peace. Towards this end, it is imperative that we, the people of this world, declare our responsibility to one another, to the greater community of life, and to our future generations. To realize these aspirations, we must decide to live with a sense of universal responsibility, identifying ourselves with the whole Earth community as well as our local communities. In the words of Helen Keller, I quote, "Alone we can do so little, together we can do so much," unquote. The spirit of human solidarity and kinship with all is strengthened when we live with a reverence, gratitude, and humility for the gift of life. So with this, I would like to end my presentation today. And I hope that whatever I've been able to share, taking inspiration from the different myths and legends from Indian and from Greek, from Roman mythology, I have tried to relate it to the characteristics which a mediator should have, to the nature of conflicts, to the basic concept and the ethos of the concept of mediation and the role that mediation can play in bringing about a better, a more positive, a more prosperous, a more productive, and a more peaceful world order. And again, I'd like to thank the Bangladesh International Mediation Society for this opportunity. And I hope, and I also call upon all my peers, all my friends and colleagues of the legal fraternity, my mediator friends, members of the bar and the bench, to continue engaging in their efforts in promoting mediation and taking mediation globally to a different level, because if we don't do it, who will? And the future of mediation, of dispute resolution is in our hands. And I hope that initiatives like this continue, and I hope I can play a more positive and a more instrumental role in promoting the same. Again, I thank you all for your time. I apologize for the earlier technical problems, but I hope that my insights have been helpful in highlighting the role of mediation, as is the theme of today's conference, in the dispute resolution process. Thank you very much.
Many thanks from all of us. I'm grateful for the time you have spent in careful preparation to present us with meaningful presentation, considering the role of mediation in resolving disputes. Thank you once again. Moving to our next session, concurrent session, I would like to request our guest of honor, Mr. Justice Somendra Sarkar, retired judge, Supreme Court of Bangladesh. Mr. Justice Somendra Sarkar. So.
I think it is best, perhaps, Justice Somendra Sarkar, if you leave the meeting and join again, and this time make sure you join with the computer audio.
আমি তো কথা বলতেছি না, চাচ্ছি না। আবার ওইখানে মিটিং এ ঝামেলা হয়ে যাবে।
Still no sound, I think.
তো চলছে তোমারটা আমি বুঝতে দেইনি
টেকনিক্যাল প্রবলেম বোধ হয়।
ওই যে কয় ঘন্টা পর তাহলে কত ঘন্টা জন্য দেয় যে আবার
হ্যাঁ হইছে
I wonder whether we should move to the next speaker and come back to Justice Shovendra.
Yes, sir. I think we do that because we have our conference timing till 3 p.m. And actually, we have respected participants from various countries where we have got almost 12 hours of time differences. So considering that, I would like to request our next honorable speaker, Mr. Mohammad Rukunujaman. He is the District and Sessions Judge, Nari o Shishu Nirjaton Daman Tribunal 2, Rangpur. Sir, your time will be 5 minutes only. Thank you, sir.
Respected Chairperson, Honorable keynote speakers, guest of honor, learned participant, and
আমরা শুনতে পাচ্ছি স্যার।
Proceed. Guest of honor, honored participant, and ladies and gentlemen, good afternoon. Much have been talked and discussed regarding mediation in this session. All the potential issues and suggestions have been mentioned by the honorable speakers in their valuable speeches. In this stage of this session, I like to submit some statistics and data regarding mediation. The judiciary of Bangladesh has taken some initiatives in this regard, and apart from these recent initiatives, we already have some provisions in some of the existing laws which prescribe for resorting to mediation as alternative mode of resolving disputes. The laws that prescribe for the Legal Aid Amendment Act 2015, this legislature professes for the mandatory compliance of mediation mechanism for the cases which are intended to be fixed with aid of the government legal aid. And with the insertion of this provision, a huge number of cases are being of the result, which shows a beacon for hope to reduce the case backlog. Likewise, Section 89A of the Code of Civil Procedure, Section 89C provide for mediation at the appellate stage. The Orthorin Adalat Ain Section 22, Family Court Ordinance 1985, the VAT Act 1991, Conciliation of Disputes Board Act 2004, Labor Act, and EPZ Trade Union Act. Recently, in our country, initiatives have taken to reach a compromise in dowry claim disputes through courts. Dispute regarding dowry claim pending before Nari o Shishu Nirjaton Daman tribunals are being settled successfully through courts now. After amending the law in this regard, a large number of cases is mediated through this process. The outcomes of the initiatives. The statistical data, the Ministry of Law, Justice and Parliamentary Affairs suggests that 50% of the family disputes are resolved through this mediation process, both at the pre-trial and the post-trial stage. As per the statistics of 2019, more than 30,000 Orthorin cases have been resolved through the mediation under that law. And more than 15,000 cases have been resolved through the Section 89A and 89C of the Code of Civil Procedure in the year of 2019. But the rate and the number of the court cases resolved through the mediation mechanism is very little in comparison of the pending cases and the influx of the case in the court. The reasons for the failure of the mediation mechanisms are to properly address to redress the problem. Those are lack of institutional mediation skills, scarcity of trained judges and the lawyers on mediation, people's ignorance as to the mediation mechanism and the benefits of the mediation, non-binding effect of the mediation results, scarcity of the mediation forum, lack of systematic and uniform mediation laws different legislation prescribes for different mediation mechanisms. Our recommendations in this regard are: harmonized uniform area legislation has to be introduced. The decision in the mediation has to be given a binding impact. Intensive training for creation of skilled mediators among the judges and the lawyers have to be introduced. Exclusive mediation course on pilot basis has to be introduced. Necessary legal provisions has to be introduced in the laws to facilitate the concept of mediation. It's not possible to settle a large number of cases through the judicial process. The court in our country is already overburdened of pending cases, so mediation may be the effective key to resolve dispute, which can help to decrease the number of pending cases. To resolve disputes, resort to mediation may be the slogan of this day. Thank you all. Thank you again. Good afternoon.
Thank you so much for your wonderful speech. That really taught so many things, and thank you so much. I'll be heading towards our next honorable speaker, Mr. Mohammad Shaukat Ali. He's the Chief Judicial Magistrate from Rangpur. Sir, your time is allotted for 5 minutes only.
I would like to interfere. Mr. Shaukat Ali is absent today. On behalf of him, Mr. Dilwar Hussain, Senior Judicial Magistrate.
Yes, sir. Thank you, respected moderator, for allowing me to say some word on behalf of my sir, Chief Judicial Magistrate of Rangpur. For an unavoidable circumstances, he is absent now, so I am representing him in his behalf. Actually, today we have attended a highly significant virtual conference, and I am delighted to be here because already I have been highly enriched from lectures from various speakers. In this conference, I pay my homage and respect to Honorable Chief Guest, Mr. Justice Muhammad Ali Sir, most senior judge, Appellate Division, Supreme Court of Bangladesh, and recipient of International Mediation Award. I also pay my respect to keynote speaker, Lady Justice Nancy Alous, and I also pay my respect to my sir, Mr. Muhammad Shahanur, Senior District and Session Judge, Rangpur. I will not lose my time. I collectively pay my homage and respect to all speakers and guests from home and abroad. Today, I have followed all lectures. I have no more to add, but I will just mention 2 barriers to mediation. As a trial magistrate in my court, I follow, especially in case of mediation of family matters in dowry-related cases. Suppose a case has come up to me for dowry claim, but when we open the case for mediation, and various matters arise before us. Suppose case is for mediation, but between the parties, there are several disputes regarding maintenance, paternity, validity of marriage, forgery about kabinnama, in some cases theft or cheating. But matter is, one case is before me, but other cases in different forums. In that cases, I face barrier for collective mediation. Only one case before me, other cases in other courts. In that case, all the parties are willing to reach agreement, but for legal barriers, as because I have no jurisdiction over all cases, I cannot conclude the mediation. This is one of the barrier I face in my practical working experience. Although this requires policy matters and amendment of legislation, but I draw attention to our Honorable Chief Guest, Mr. Justice Muhammad Iman Ali sir, whether this barrier can be resolved through amendment of related legislation or creating harmonious forum so that that forum can address all kind of disputes in one forum. This is one point, and another point. Access to justice is very essential for all citizens, but as the dispute arise at social level, grassroots level, the disputants, they come to court in district level or thana level. They have no appropriate access for mediation in local level. Although there are traditional Shalis system or Panchayat system or village court, but we should have formal legal structure covering mediation mechanism in local level. These was 2 points to mention from me, and actually I will not extend my lecture. I will conclude. At last I will say I have been very highly enriched in this session, and this information will help me in my practical trial procedure side by side in mediation in cases where the case can be mediated. Thank you all.
Thank you, sir. Thank you so much. I'd like to call upon our next honorable speaker, Mr. Muhammad Haider Ali. He is the chairman of District and Sessions Judge, Labor Court, Rangpur. Mr. Haider Ali.
Honorable Chief Guest, Honorable Judge of Appellate Division of Supreme Court, Bangladesh, His Lordship Mr. Justice Muhammad Iman Ali sir, respected keynote speaker, guest of honor, Honorable Justice, respected Senior District and Session Judge, guest speaker, respected Judge, Nari Shishu Nirjan Daman Tribunal to Rangpur, learned Acting Chief Judicial Magistrate, all members of BIMS and organizer of online conference, distinguished participants, ladies and gentlemen, Assalamu alaikum, adab, and very good afternoon.
Microphone is muted. Please unmute your microphone.
So your microphone is muted.
Mediation is an alternative dispute resolution process which is growing rapidly in Bangladesh. Understanding the importance of mediation for the speedy and co-effective justice, mediation has already been made mandatory in court-based formal justice system in Bangladesh. Distinguished presence, mediation plays a crucial role in resolving the family disputes, and it helps the family to stay intact and unbroken. This is why provision of pre-trial and post-trial mediation have been inserted in Family Code Ordinance. Settlement of conflicts through mediation ends litigation finally and completely. Mediation acts filtering tool to tackle unusual influx of the litigation. Moreover, it buries a dispute in its inception. Mediation can lead to win-win situation. In a win-win situation, both parties come out on top. Having regard to this fact, the Code of Civil Procedure has been amended to provide for the scope of mediation even in the appellate stage. There are also significant provisions for mediation under the Orthorin Adalat Ain 2003. This law deals with the legal process to recover loan provided by banks and non-banking financial institutions. After certain amendments, now mediation remains as the only method adhered under the law. Importantly, attempt for the mediation is mandatory under this parliamentary enactment. We know Considering all the limitation of the complex formal the court system and the socio-economic context of Bangladesh, mediation is a promising alternative for ensuring access justice, especially for the poor and unprivileged section of people. Apart from the court-based mediation, district legal aid office, the country are resolving the dispute via mediation. In the process, lots of civil and criminal conflicts are being settled even before going into the court. District legal aid officers, judges, and magistrates are doing magnificent job as a mediator, be it through mediation or otherwise. We, the judicial officer, we are committed to are giving our level-based effort for the quick disposal of the case. But at the same time, parties to the case and lawyers have a big part to play in the connection. In a case of civil and family dispute, the day on the which suit for fixed for the mediation, unfortunately, lawyers and parties to suit remain absent. Therefore, participants of lawyer and parties to the suit in the mediation process should be made mandatory. To that end, Code of Civil Procedure and the Family Court Ordinance are required to be amended. Litigant people have no proper idea about the mediation process and its positive sides. That's why litigant people need to be aware as well regarding the court-based mediation. Mass awareness should be created as to mediation system conducted by District Legal Aid Office. Honorable Presence, mediation is still a developing concept as an alternative dispute resolution mechanism in Bangladesh. It has a long way to go to serve its true purpose. Despite its limitation, it can be said that it is playing a vital role in ensuring the access justice for the people, with the courts of Bangladesh being flooded overburdened. Before parting with I would like to the privilege to express my profound thanks and gratitude to the concerned personalities for the inviting me here and allowing me to have the few words on these very important topics. In fine, I want to conclude wishing success of the conference. Thank you very much.
Thank you, sir. Thank you so much for your wonderful speech. Can we see Mr. Shomendra Sarkar?
Mr. Justice Shomendra sir.
Sir, are you there?
Still problem with his microphone. Yes.
Is someone there to help him? I think there's a.
I think Mr. Goswami will have to provide him with a better laptop next time.
Yeah, definitely.
It is my great pleasure to join this program.
Okay, so let's wait for, let's give him some time.
Hello, sir. Oh.
Just like mediation, the more we use it, the more friendly it will become.
Now. স্যার ওনাকে পাওয়া যাচ্ছে অনেকে পাচ্ছি না স্যার এখন আর।
Then let us proceed then, Sylvia.
Thanks, sir.
Okay, so
তুমি proceed কর, Sylvia.
okay, sir. Thank you. I'll go to our last speaker for today is Mr. Kondokar Mohammad Rafiq Hasnain. He is the advocate and accredited mediator, regional director Bangladesh of Bangladesh International Mediation Society. So, only 5 minutes.
Thank you, Sylvia. Good afternoon. Conference of Mediation of Rangpur Region, Honorable President, learned District Judge, Mr. Shahinur, Senior District Judge Rangpur, keynote speaker, Mr. S.N. Goswami sir. He is the original person of mediation. He is working for mediation day for day after always he working for mediation. District Judge of Rangpur, Mr. Ruknuzzaman Haidar Ali, Chief Judicial Magistrate Rangpur, Chief Judicial Magistrate Lalbanihat, Chief Judicial Magistrate Thakurganj, Chief Judicial Magistrate Nilphamari, our colleagues, advocates, and others. Welcome from Rangpur. It is pleasure for me. We arranged a meeting for mediation for Rangpur division. Rangpur is a historical district situated in northern part of the Bangladesh and southern side of the Himalaya. It is also mythological values. It is believed that the great Ganga river flown over greater Rangpur once upon a time. The first actual democratic leader, King Raja Gopal, was elected in the state when it was Kamtapur. Warrior Chirarai, artist Atul Prasad, social reformer Panchanan Burma, Raja Ranmohan Rai, revolter Devi Chaudharini, Bhavani Patok, Fakir Majnu Shah, Nuruddin Bakir Jong, great feminist Begum Rokeya are from this Rangpur. Khudiram, Prafullo Chaki, Netaji Subhash Chandra Bose, Kobi Nazrul, Bangabandhu Sheikh Mujibur Rahman, at different times come to Rangpur and blessed us. Him since working in this area to listen the litigation problems and makes the Rangpur great. Honorable guests, this is my introducing speech. I want to speak in Bengali. আমার মায়ের ভাষা, আমরি বাংলা ভাষা। বাংলা ভাষায় আমি দুটো কথা বলে আজকে শেষ করতে চাই। রংপুর সম্পর্কে আপনারা জানেন, বাংলাদেশের সর্বোত্তরাঞ্চলের জেলা। আমরা সর্বত্র দিন-রাত লড়াই করে চলছি প্রকৃতির সঙ্গে, মঙ্গার সঙ্গে, শিক্ষার সঙ্গে। বাংলাদেশের যতটা উন্নতি হয়েছে, আমাদের এই অঞ্চলে ততটা উন্নতি হয়নি। শিক্ষায় আমরা পিছিয়ে, অর্থনীতিতে পিছিয়ে, আমাদের দুর্দশা শেষ নাই, বন্যায়, খরায় আমরা সবসময় যুদ্ধ করছি। নাগের বাগের পাহারাতে হচ্ছে বদল দিনে রাতে, আমাদের অবস্থা ঠিক এইরকম। একসময় হিমালয়ের পাদদেশ ঘেরায় রংপুর, গঙ্গা অববাহিকার এই রংপুর কোন রকমই টিকে আছে। উন্নতির ছোঁয়াটা আমরা এখন সেভাবে পাইনি। দেশের বিচার ব্যবস্থাও যে অবস্থা, হাজার হাজার মামলা ঝুলে আছে, নিষ্পত্তির হবার সুযোগ নেই। আর সব মামলা নিষ্পত্তি করবার জন্য পর্যাপ্ত জজ, পর্যাপ্ত কোর্ট, পর্যাপ্ত লজিস্টিক সাপোর্ট নেই। সে কারণে এই দেশের মামলাসমূহকে নিষ্পত্তি করতে গেলে, মানুষকে মামলা জট থেকে রক্ষা করতে গেলে মিডিয়েশনের যে প্রয়োজন, সেটা বিন সেই কাজটি করে চলছে। আমরা এই কাজটি করে চলছি আমাদের নেতা এস.এন. গোস্বামী স্যারের নেতৃত্বে। আমাদের সঙ্গে আছেন আপিল বিভাগের জ্যেষ্ঠ বিচারপতি ইমান আলী স্যার। ইমান আলী স্যারের নেতৃত্বে আমরা ঠিকই এগিয়ে যাব। উনি এবার জাতিসংঘ থেকে পুরস্কার পেয়েছেন মিডিয়েশনের ওপর, আর আমাদেরকে এগিয়ে যেতেই হবে। সৌমেন্দ্র স্যার দীর্ঘদিন এই এলাকায় কাজ করছেন, আহমেদ সোবান স্যার আছেন, এবং আমাদের রংপুরের জেলা জজ শাহিনুর স্যার অত্যন্ত আন্তরিক, নিশ্চয়ই কাজে আমাদেরকে সাহায্য করবেন। যেখানে ইমান আলী স্যার আমাদের সঙ্গে আছেন, আমরা বিশ্বাস করি কান্ডারি তরির পাকামাজি মাল্লা, দাড়ি মুখে সারি গানলা শরিক আল্লাহ। আমাদের যে প্রত্যয় সেটা বাস্তবায়ন হবে। এডিআর সম্পর্কে আমরা জানি, সকলেই জানি, কিন্তু এডিআরটাকে বাস্তবায়ন করতে হবে, সেইভাবে মনোপুতভাবে কাজ করতে হবে, এডিআরটা হৃদয়ে লালন করতে হবে এবং এই হৃদয়ে লালনের মাধ্যমে এডিআর বাস্তবায়ন করতে হবে। এডিআর বাস্তবায়ন করতে পারলে তার সঙ্গে যদি মিডিয়েশন কার্যকর ভূমিকা পালন করা যায়, তাহলে বাংলাদেশের মামলা জট কমে যাবে। জাতির জনক বঙ্গবন্ধুর কথায় আসি যে এই মামলা, এই বাংলাদেশের মামলা থেকে মানুষকে রক্ষা করতে না পারলে এই অর্থনৈতিক অবস্থাটা আগানোটা কঠিন হয়ে দাঁড়াবে। সেই জন্য আমাদেরকে সকলকে সচেষ্ট থাকতে হবে। একটা বিষয় মনে রাখতে হবে যে মিডিয়েশনের বিষয়ে দক্ষ জনবল তৈরি করতে হবে। শুধু মিডিয়েশন বললেই হবে না, অদক্ষ মানুষকে দিয়ে, নন এফিসিয়েন্ট, নন প্রফেসিয়েন্ট মানুষকে দিয়ে মিডিয়েশন করা যাবে না। সেই মিডিয়েশনটা আর একটা অবিচারের নামান্তর হয়ে যাবে। দক্ষ জনবল সৃষ্টির জন্য আমাদেরকে কাজ করতে হবে, প্রশিক্ষণ দিতে হবে। আইনজীবী, অন্যান্য সমাজের শিক্ষিত মানুষকে দিয়ে প্রশিক্ষণের মাধ্যমে এই দেশে দক্ষ জনবল তৈরি করা গেলেই মিডিয়েশন সফল হবে। পৃথিবীর বহু দেশেই এখন কারাগারগুলো জনশূন্য, সেখানে মানুষ আর কোনো অপরাধ করে না। কারাগারগুলোকে সংশোধনাগার হিসাবে পরিণত করা হচ্ছে। আমি বিশ্বাস করি, আমি নৈরাশ্যবাদী নই, এই বাংলাদেশেও একদিন এমন একদিন আসবে কারাগারে যাবার মতো কোনো লোক থাকবে না, এই দেশে কোনো অপরাধ করবে না। এতে সকল মানুষ এই মিডিয়েশনের আলোয় আলোকিত হবে এবং এই আলোয় বাংলাদেশ জ্বলে উঠবে। এই বাংলাদেশ পৃথিবীর মধ্যে একটি আলোকিত দেশ হিসেবে গড়ে উঠবে। আমাদের যে পরিকল্পনা রয়েছে 2041 সালের উপকল্প, সেই রূপকল্প পরিকল্পনা বাস্তবায়নের জন্য মিডিয়েশনের মাধ্যমে কোর্টের এই মামলা জটটা নিরসন করা দরকার। সেই জন্য যদি এই একটি জায়গায় পিছিয়ে পড়ে থাকি, তাহলে 2041 সালের উপকল্প সফল হবে না, সফল হবার সুযোগ থাকবে না। তাই সকলের কাছে আমার আহ্বান, আমি বিমসের রিজিওনাল ডাইরেক্টর হিসেবে কাজ করছি। আমার দায়িত্ব নেবার পরেই রংপুর বিভাগে এটাই প্রথম একটি বৈঠক আমরা করতে পারলাম। বৈঠকটা অ্যাকচুয়াল বৈঠক হবার কথা ছিল। ইমরান আলী স্যার একসময় টিকিটও কেটেছিলেন, রংপুরে আসবেন, রংপুরে তার পরিবার সহ থাকবেন, আমাদের সঙ্গে এই মিটিং এ যোগদান করবেন। আমরা আরডিআরএস রুম বুকিং দিয়েছিলাম, তার সাগির হাউসে থাকার ব্যবস্থা হয়েছিল। তার সঙ্গে এই আলোচনা হয়েছিল যে রংপুরের ঐতিহাসিক জায়গাগুলো তিনি পরিদর্শন করবেন। সে স্বাধীনতা সংগ্রামী দেবী চৌধুরানীর বাড়ি উনি যাবেন, তারপরে বেগম রোকেয়ার বাড়ি যাবেন, এই এলাকার সম্পর্কে জানবেন। আমরা তাকে নিয়ে অনেক সবাই মিলে একটা মজার একটা উৎসব করব এই মিডিয়েশন কনফারেন্সটাকে। কিন্তু কোভিড-19 আমাদের সে প্রত্যাশাটাকে একটু মুটিয়ে দিয়েছে, বাধাগ্রস্ত করেছে। তাতে কি হয়েছে? আগামী যে দিন আসছে, উদয়ের পথে শুনিকার মানে ভয় নাই, ওরে ভয় নাই, নিঃশেষে প্রাণ যে করিবে দান, ক্ষয় নাই তাই ক্ষয় নাই। আগামী সূর্য উদয়ের জন্য অপেক্ষা করতে থাকবে। তবে সব দিক দিয়ে লক্ষ্য রাখতে হবে, একটি বিষয় লক্ষ্য রাখতে হবে, এই বাংলাদেশের 17 কোটি মানুষের জন্য সকলকে কাজ করতে হবে, তাদের জন্য চিন্তা করতে হবে। কবিগুরুর একটি কথা বলে আমি শেষ করতে চাই, ওই সব মুরম্লান মুখ মুখে দিতে হবে ভাষা, ওই সব শান্ত শুষ্ক ভগ্ন বুকে ধনিয়া তুলিতে হবে আশা, ডাকিয়া বলিতে হবে মুহূর্তে তুলিয়া শীত, একত্রে দাঁড়াও দেখি সবে। সকলকে ধন্যবাদ যারা সময় দিয়েছেন এতক্ষণ ধরে, যারা বক্তব্য দিয়েছেন এতক্ষণ ধরে। আপনাদের জ্ঞান গর্ব বক্তব্য আমাদের জীবনে পাথেয় হয়ে থাকবে এই জন্যে। আর বিমসকে, বিশেষ করে বিমসের চেয়ারম্যান গোস্বামী স্যার, উনি এই সংগঠনটাকে, এই অনুষ্ঠানটাকে সর্বতভাবে সংগঠিত করবার জন্য চেষ্টা করেছেন, আমাদের সহকর্মীরা কাজ করেছেন। সকলকে বিমসের পক্ষ থেকে ধন্যবাদ। এবং রংপুরের জেলা জজ, বিশেষ করে রংপুরের জেলা জজ, তাকে আমি অনেক যন্ত্রণা দিয়েছি, চালিয়েছি, তিনি খুব স্বাভাবিকভাবে এই বিষয়গুলো নিয়েছেন। তাকেও আমাদের বিমসের পক্ষ থেকে ধন্যবাদ জানিয়ে আমার বক্তব্য শেষ করছি। খোদা হাফেজ, বাংলাদেশ চিরজীবী হোক।
Thank you so much, sir, for your wonderful speech. May I request our honorable chief guest to say something? Would you like to say something, sir?
Well, if you give me the floor again, we never refuse the microphone. Thank you very much. I want to thank all of you for being patient with us for the last 4 hours, particularly Jamila. It is now 5 o'clock in the morning in Guyana. I thank you, all of you. We have, I think, received a lot of inspiration, a lot of hope from all of you. And I believe together we can move forward. Tomorrow is another day. Rangpur, we missed Rangpur. The new year will start on the 1st of January, and hopefully we can come back to Rangpur and visit all those sites that have been promised to us. But so far as mediation is concerned, we are happy that we are going ahead with training. And I think today's message is that mediation is not easy. It is not an easy option for anyone. But nevertheless, we have to try. We have the problems of the disposal rates in our courts, the problems of the backlogs. And in order to get rid of those, the only way I feel is avoid litigation, avoid arbitration, because both of those have now become bound in the time-consuming factors, the cost-consuming factors. The efficiency has gone. So we have to find new ways. I just hope that in the end, we do not have mediation becoming in the same way so technical that it becomes beyond the reach of the general people, general public. We hope that mediation will be a solution for the litigant public, which will give them quick, cheap relief. And that way, we will also make sure that their lesser cases will be coming to the courts. I thank every one of you. I wish and hope that all of you who have participated today will help us in taking mediation forward for the years to come. And I finally end by saying, in this month of victory, Joy Bangla. Thank you, everyone.
Thank you so much, sir. Thank you once again for the wonderful speech. I'd like to request Mr. Mohammad Shahinur. Sir, would you like to say a few words and conclude the session? Sir, please.
Thank you, everyone.
Unmute yourself, sir.
Thank you, Sylvia. I'd like to give my concluding speech in Bengali and English, since it's the month of our independence. Honorable Chief Guest, Honorable key speaker, special guests and speakers, dear participants and viewers, I am very happy for your kind and patient long time presence in this auspicious conference. Your heartiest participation has encouraged me a lot to carry out and enforce mediation revolution. To my knowledge, mediation training is an important subject. I believe at the guidance and direction of our Honorable Chief Guest, His Lordship Justice Muhammad Iman Ali, I shall make myself and my brother judges and learned advocates a good and skilled trainer through different training courses of mediation. Dear viewers, I want to make you know through this conference that with the help of judges and learned senior advocates of Rangpur Division, I shall be able to produce experienced and trained mediators, and for this, I shall try my best to make a good team of trainers, including myself. Regular training will be conducted in Bengali mother language and under international syllabus of mediation. I hope this will help us to mobilize our judicial process through mediation. At the end, I'd like to thank to all the speakers, including our chief guest speakers and other speakers for their resourceful deliberation on mediation. At this stage, I'd like to say something in Bengali. মাননীয় প্রধান অতিথি এবং অন্যান্য যারা শুনছেন, প্রথমে আমি বলেছিলাম যে আমরা আসলে খুব আনফরচুনেট যে রংপুরে আপনাদেরকে আমরা হোস্ট হিসেবে পেলাম না। তারপরেও আজকের এই সুন্দর প্রোগ্রাম, এই কনফারেন্স সবার অংশগ্রহণে সফল হয়েছে। আমি সবাইকে অসংখ্য ধন্যবাদ জানাচ্ছি, বিশেষ করে টিমসের চেয়ারম্যান এবং আজকের উপস্থাপিকা সুন্দরভাবে এটা প্রেজেন্ট করেছে। আর সবাইকে ধন্যবাদ জানিয়ে আজকের এই কনফারেন্সের এখানে সমাপ্তি টানছি। থ্যাংক ইউ ভেরি মাচ। থ্যাংকস এ লট।
Thanks to everyone. So that's all we had for today. Thanks to all of you. Actually, sorry for there was a little bit of technical problems. We saw that, but anyways, and Rangpur we really really missed out being in Rangpur, but hopefully next year we are hoping to be in Rangpur, and let's pray and hope that everything gets better soon. Yeah, and you all stay safe, stay in good health. So yeah, good evening and have a good day. Thank you all.